When would you like to bring that in, Ms. Emerson?
What, do you have a mini docket day? Or-
I have one Monday. Y'all have different names for it over on the west side of the circuit. We just call it docket day is Monday, the 4th, right? 4th? 2nd?
4th.
No, the 4th.
Monday the 4th.
Yes, okay. See, sometimes I'm right.
Monday is fine, Your Honor. What time?
9 o'clock.
9 o'clock, yes.
All right, we'll put you on May 4th. My son would kill me if I forgot May the 4th. Okay. May 4th, 9 o'clock.
Thank you, Your Honor. That's all my business. I'll see you Monday.
All right, thank you, Ms. Emerson. All right, Mr. Gilbert. Morning. Give me just a second to get to your, well, hold on a second. What do you have, Mr. Gilbert?
One case, Your Honor, Randall Thibodeau and 25 CF 2290.
Oh, he was on Monday, on the docket Monday, but he was in custody, right?
Right, he's got an RPO violation that's riding on this date. What we'd like to do is just continue that out for a control date. And he's got a companion case that we were in on Monday, 25 CF 2039, that we're anticipating pleading out on Monday. We would roll this into that.
You want to do that all on Monday? Yes, sir. All right. Is he here? I think he's listed under Rivers.
I'm gonna go back and make sure, so obviously we had struggled with the site yesterday, but we'll make sure we're filed on him.
Nobody prepped it. She said heard the case in 27, but didn't discuss this case.
Yeah, the 25th, or the 25 CF 2039 was already, well, let's see. What did we do that day? Okay, so both of his cases will be May 4th for plea or continue? That's what you announced on the other one? Okay. All right, we'll see you back on Monday for that.
Thank you, Your Honor. Have a
All
good
right,
day.
thank you, Mr. Gilbert. All right, Ms. Merrifield. Morning.
Brittany Merrifield on behalf of Corey Valley. It's 23 CF 1996. There is a waiver on file. I requested that he not be transported because he has max and he's also wheelchair bound. Judge, we just took this case over,
saw
filed
that.
our notice March
month.
the 25th. Yes, sir. We've received about 32 exhibits. I am working through those as fast as I can. I did
I
speak
think they
with
filed the
ASAP.
33rd since.
They did. They did, Judge. So I'm requesting that 6/24 pretrial. I do anticipate that I'll need more time than the June pretrial, but I'd like to keep it on June just so we can track. That way, if there's anything missing, we can address it.
And certainly not aimed at you, Ms. Merrifield, but as I always say in these types of cases, when you take over an old case, you take it as it is.
Yes, sir.
So I understand. I'll give you a little leniency on having some time to get ready, but it's like a 2.5-year-old case already, right?
It is a priority in my office, Judge.
All right, I appreciate it. Ms. Merrifield, so we'll put June 24, 9 o'clock for Mr. Valley.
That should be all I have today, Judge.
Okay.
Thank you.
Mr. Powell? You could get Mr. Stewart to cover for you like you did everyone else.
Figured I'd be here, Your Honor.
Okay. All right, Timothy
Right down the
Thacker.
road. I did get on the list today for once.
You beat the list, that's good.
Before Your Honor is Timothy Hacker, Dixie Dan Powell on behalf of Timothy Hacker, VOP, Your Honor. And we would like to continue it. We just got on the case, Bo and I, and we got the order substituting Bo for the public defender, I believe should be.
Yeah, I think I signed it on the 15th. Are y'all both going to be attorney of record?
I
You
think
and?
we're
Bo
both
Powell?
attorney of record, but I think it's mainly Bo's case. So.
I see you both listed on here, but I only saw his name on the order, that's why I asked.
Yeah,
Not
I
a
think
big deal.
that's kind of the meaning of it.
All right, you understand that, Mr. Thacker? We're going to continue your case till June 24th. Based on y'all's request, we'll see you back on June 24th for all 4 of your cases.
Yes, Your Honor.
All right, thank you, sir.
Thank you.
All right, Ms. Dudley. Did she walk out? Okay. Mr. Williams, Charles Williams?
I just pulled all.
Dudley's.
All right, it's gonna take a minute to move them.
All right, give us a second so they can get your inmate up.
Stand by.
You can say where you're at, Mr. Williams, just. Hold all Ms. Dudley's clients, and she's probably talking to one of them in the back, so we gotta move them aside to bring yours in.
I have one that's not in custody I could call up, Your Honor.
Oh, let's call that one then.
It would be Doremus King. That's 25 CF 1500, Your Honor. Mr. King was in custody, bonded out recently. I believe we're going to have a resolution in this case, Your Honor, but Ms. Leone's not here this morning. She has someone covering for her, but because of the
Well, I called it
case-
last continuance last time, so are we sending it for plea or trial?
That's fine with me.
Okay. My trial list upstairs.
What is your plea date, Your Honor, in case there is a
Monday.
resolution? I have a jury selection on Monday. Is there another one short of the 24 June date? Or,
Well, I'm setting the case for a trial. You can plea on either Monday or Friday next week. If it's negotiated and y'all tell me by Monday that that's what's gonna happen, I'll accept it. Usually I don't take negotiated pleas after the Monday docket day. But because this is a last continuance, I had told you last time.
yes, I understand, Your Honor.
Because I think it was set for trial last time around, if I'm not wrong.
Don't.
Let me
recall
double check.
that.
I mean, again, tell me if you think I'm wrong
But,
in some way, but my notes, and I think the clerk's notes from last time, is I told you last time to continue it, because there wasn't anything else left to do.
No, there was just I had meant to talk to Ms. Leone earlier. We hadn't been able to get together, and I didn't realize that she wasn't going to be here today.
Okay.
But whatever day you want to set it for. I think, is she going to be back this week at all?
She'll be back on Monday, and you can get in touch with her today. It's
Yeah,
not a
I
problem.
can, I can email her, talk to her, that sort of thing.
Okay.
So,
So you all don't have anything figured out yet, as far as a final,
no, not for a final. Right.
so what would you like to do?
I would like to set it for, well, I was going to ask for a plea day, because I do expect it to resolve.
All right, you want to put it on Thursday next week?
I can have just a moment, Your Honor. Double check. I think that'll work.
Because the case is not terribly old, but
I understand.
But when I ask the questions, what else needs to be done, and I get told there's nothing else to do, then I just don't like to continue cases just to kind of kick the can, so to speak.
Understand, Your Honor. That's the 7th?
Yes, sir.
That'll be fine, Your Honor.
All right, let's put it on for May 7th at 9 o'clock for purposes of a plea.
Thank you, Your Honor.
All right,
And if we don't get it resolved, we can set it for trial then.
we certainly can. All right, we'll see you back on May 7th at 9 o'clock, Mr. King. Stay in touch with Mr. Williams, and I'll see you back on that day.
We're in good communication, Your Honor.
Okay. All right. Do we have his inmates now?
I have some, you have some juveniles, you have some.
I understand.
And some access, so they can't all be in
Understand.
together right now. Jack Barr, if you're ready to
Okay.
Mr. Barr, come on out, please, sir. Stand on that little space there.
Your Honor, Jack Barr, 22 CF 1851, 23 CF 1016, and 24 CF 2616, Your Honor.
Excuse me, Your Honor. I have time to speak with Mr. Wilson after, Mr.
With-
Williams, and there's a couple things that I'd like to address with you, if I may.
Well, why don't you discuss it with Mr. Williams first, since he's your counsel, and I can recall you. Can he talk to him in the
I had
back?
gone to see him at the jail last night, Your Honor, but the count lasted too long, and then in his status, they weren't able to bring him to me. So, okay.
All right. Can we set him up to speak with him? All right, we'll recall you, Mr. Barr. Just make sure if there's anything you want to discuss with the court, you talk about it with your lawyer first.
He's not.
This is Tyshawn Morris, Your Honor. It's 4 case numbers, 22 CF 1436, 23 CF 2394. Those are VOPs. And then 2 new case numbers, 25 CF 1174 and 1175. Mr. Sprouse and I have been talking a little bit about this case, Your Honor. I think this should be our last time up. If we don't have it resolved by the next pretrial, then we'll either set it for trial or we either have a resolution or set it for trial. Is that good with you, Mr. Sprouse?
That's correct. We've clarified what the offer is this morning, so I expect it to be resolved by then.
This
Will there
was
be
a
anything
case-
else to do other than this negotiation?
I don't think so, Your Honor. This was originally a situation that was cocaine, and then when it went to the lab, it came back fentanyl, so that's caused a little bit of complication. Other than that, we're ready.
I still have it listed as cocaine. Is it over 28 grams of fentanyl?
No, it's between 4 and 14, I believe.
So the minimum mandatory would be 7 years.
Okay. And the reason I ask again is it's listed on mine still as cocaine trafficking over 28 grams. Obviously, over 28 of fentanyl would be a much different situation. All right. Sorry about that, Mr. Morris. I know you probably don't like the judge talking about things that aren't what your case is all about. I just wanted to make sure of that because obviously that would change a lot of things as to what they're discussing. I'll put it down for June 24th at 9 o'clock for your next pretrial conference. However, if it's not resolved at that point, I would expect it to be set for trial.
Very well, Your Honor.
All right.
Thank you.
Thank you, Mr. Morris.
Your Honor, this is Mr. McLaughlin. That's Trevante McLaughlin. I'm appointed in 25 CF 1383. This is the case we talked about the other day. There's a new case. I know
Yes.
that the public defender has conflicted. I'm not sure where the regional counsel, I didn't see if the regional counsel had taken any action yet, so I know that the state will be wanting to do both of these cases at one time.
Sure. Hold on just a second. I'm trying to pull that up, and the system's a little slow this morning. So he also has 26 CF 726. That's the case we had the pretrial detention hearing on last week. I don't see where,
Sure if it was Mr. Klein.
Mr. Williams, the other Mr. Williams?
Mr. Williams.
Oh, he's, Mr. J. Williams. This is McLaughlin. This is the one we had that pretrial detention on last week. And we don't have anything, have y'all looked at it as far as a conflict yet on this particular case?
We have, Judge, and I'm trying to remember what Mr. Russell said about it.
Okay.
My thinking is that we agreed that we were going to have to withdraw on it.
Okay.
But let me contact him just to confirm that, or else go through my emails and.
Because it looks like you represent the co-defendant in his case that's here today.
Then
So
we still have the
conflict, okay. If you could just make sure that gets through. So Mr. McLaughlin, what's ultimately going to happen is the public defender is going to file a motion to withdraw from your new case. I'll appoint the regional office of conflict counsel. Then Mr. Kleins will have to determine if there's a conflict with him representing you based on, let's see, that he represented Mr. Schaffner in another case. So most likely what will happen is Mr. Williams, Charles Williams, who's standing there next to you, will end up with both of your cases, but I have to let that go through the process. I can't just skip a step, otherwise it doesn't work right with what's called the JAC, so.
And Judge, actually, if I'm remembering right, as we stand here and talk, I'm remembering more. I think I already approved that motion.
Okay, I just don't see it yet, so,
In our staff.
okay. All right, so what do we want to do with this current case that's here?
Well, I'm assuming that the state wants to keep them together, so I'd ask for a, that 24 June date, I guess.
Be without objection.
It's going to be June 24th at 9 o'clock. I'm showing that his new case is listed for the 22nd, but that should be the 24th as well. And again, that's 26 CF 726. All right. Anything else from Mr. McLaughlin?
That's it for this case, Your Honor.
Okay. Thank you, sir. Timothy
Cochran, Your Honor, 24 CF 2690. Ms. Leone and I just finished up depositions last week. So I would ask for a continuance until that 24th date. I need to get a copy of I want to show, that was a videographed deposition of the child victim, Your Honor, so I want to be able to show that to my client. And I'm also going to be making a motion for transcripts to be made so that in case we don't get a resolution, I'll have those transcripts available for trial.
All right, Mr. Cochran's going to be June 24th at 9 o'clock. This is I know it's a serious charge, but it's about 1.5 years old, so let's make sure we're ready next time if it needs it.
Those were the last depositions we had to do in the case, Your Honor.
Okay, perfect. All right, thank you, Mr. Cochran. We'll see you back on June 24th.
Ms. Vaughn.
Your Honor, Bonnie Hahn, 25 CF 2318. Your Honor, if you'll recall, we had a VOP hearing with Your Honor three weeks or so ago, and we're set for sentencing for that for tomorrow. And I think the state and I would both request that we continue this.
For tomorrow? Yes.
Continue tomorrow's sentencing hearing?
It's the sentencing for the VOP.
Yes.
Yes.
On the VOP.
We would continue the case for tomorrow.
Oh, continue this case until tomorrow?
Until tomorrow, so we
Oh,
can do them both at the same time.
all right. So what's going to happen with the new case?
That will be handled tomorrow, Judge.
Okay. All right. So let's put both cases on for tomorrow. I know the one is already set there. Y'all expect the sentencing hearing will go forward tomorrow?
Yes.
The state
That's
expects it to go
Okay,
forward.
just want to make sure we're clear.
And that-
All right. We'll see you back tomorrow, or did we set that for 2 o'clock?
I'm
I
not
believe
sure.
It's at 2,
Was it 2? Okay.
yes. I think all the hearings tomorrow are at 2.
Well, all the contested ones typically are. Let me just double check. Yes, 2 o'clock tomorrow. Let's also just put it on the 6/24 date for pretrial purposes, so we don't forget about that tomorrow. If it's not resolved, it'll have that date.
And I think I have a juvenile left.
Well, and he's on property, we're bringing him right now.
Gotcha. I'll just step aside. I'll go see my other, Mr. Barr in the meantime.
Okay, thank you, Mr. Williams, we
Thank you.
appreciate you. And on that, do we have Ms. Dudley's cases?
They were gonna get Ms. Dudley's after we got Arnett, who is, I think, on the elevator right now.
Do we want to just bring him straight through then? All right, Mr. Williams?
And then I'll send Barr to him.
Mr. Williams? Looks like Mr. Arnett's going to be up, so why don't we take him? Otherwise, moving them back and forth is going to be a difficult situation. Then we'll bring you back up after you talk to Mr. Barr.
Very well, thank you, Your Honor.
And then I've got, Steve, I've got Chris Crawford is on Zoom.
Russell Ramey should also be.
I don't have him yet. That's going to be Maura Chisholm, Christopher Maura Chisholm. Just tell me when he's ready and I'll bring the Zoom up. I also have Cruz. So that's going to be Garcia Pena. Okay.
Carson Arnett, that's 26 CF 320. If you recall, Your Honor, we recently had a pretrial detention hearing in this matter, and
This is our
Since-
first pretrial conference.
since then, I've made a motion and you've approved it for an investigator. My investigator met with Mr. Carson a couple of days ago, so I just need to get with my investigator to talk about how that went and then meet with Mr. Carson, with Mr. Arnett personally, and see what else we need to do with regard to discovery in the matter. So I would request that continues to the 6/24 date.
All right. 6/24, 9 o'clock, Mr. Arnett will be your next pretrial conference. We'll see you back on that date.
I'll excuse myself right now.
All right, we'll see you back when you're done with Mr. Barr.
Thank you.
Who do you have up, Steve?
I've got Maura Chisholm
Okay.
and Garcia coming.
Ms. Dudley, we called you. You must have stepped out to talk to someone. So we'll call you as soon as we don't do the 2 Zooms. I haven't seen him. He probably knows it usually takes a while to get to Zoom, but I'd like to handle him while we're here. Who do we have?
Garcia.
All right, so that's Mr. Cruz.
Need a translator?
Well, then your lawyer should have asked for one. Mr. Cruz, are you there?
Yes, Judge, good morning.
All right. Your client just stepped out and told court security he needs a translator.
He does speak some English, Your Honor, but if he feels more comfortable getting a translator.
All right, well, I'm not sure if that's going to happen today because no attempt has been done by your office to do that. Obviously, I don't know who needs an interpreter until I get told. What would you like to do?
Your Honor, if he needs an interpreter, I'd respectfully ask to pass. We have a motion to withdraw, but I don't think we can proceed with that.
Okay.
Because he wouldn't, I want to ensure that he has a full understanding of.
Oh, I understand that. I just, as far as, did you want to try to hang around to see if I can get an interpreter or even if we can do it on Zoom?
Yeah, yes, Judge. I would be, yes, sir.
All right, I can't guarantee anything, but we'll pass Mr. Garcia Pena and see if we can't get an interpreter to show up via Zoom or try to do language line, but I'm not going to go through all that. I've got a courtroom full of people. We'll put it towards the end since no attempt was made before now.
Absolutely, Your Honor.
All right, we'll call you back.
Yes, Your Honor.
Maura Chisholm. Stand just left in here. Yes, please. So you're right.
All right, Mr. Crawford, are you there?
Yes, Your Honor, I'm here.
All right, Mr. Crawford, this is your client, Mr. Christopher Maura Chisholm, 26 CF 266.
Yes, Your Honor. We have a bond motion set in the court's upcoming calendar, and we're asking to continue the case.
Okay, let me just, what day is that set? Do you know off the top of your head?
I believe it's the 27th of the upcoming month. The 27th or 24th, it's around that date. I can give the
28th. I just found it, just my system's running a little bit slow this morning.
So is mine.
Oh, okay. Also, there's 2 notices, one's amended because apparently at first he said it in front of Judge Drake, which I'd be happy to do.
Maybe an easier drive for me too.
Yeah. Let's see, May 28th at 2 o'clock is the bond hearing. So we can set your next pretrial for June 24th at 9 o'clock. Obviously, if there's any need to bring it up faster, you can set those at that time.
Okay. I
All right.
appreciate that.
You understand that, Mr. Moore Chisholm? All right, then we'll see you back on May 28th for the bond hearing, June 24th at 9 o'clock for purposes of pretrial conference.
And I appreciate you allowing me to appear myself.
No problem, Mr. Crawford.
And I thank the state for allowing that also.
I'm not sure I heard back from them, but I did it without it.
They did, it was late. But
I think the relatively new rule is pretty clear on that, so.
Yeah,
For non-evidentiary hearings. All right, thank you, Mr. Crawford.
Appreciate it.
Thank you, Mr. Moore Chisholm. Have a good day. All right, Ms. Dudley.
Mr. Coleman.
Can we, Mr. Garcia, just mark this minute sheet that says needs interpreter, Spanish interpreter each time?
Yes.
Just don't want it to be something that doesn't come up.
Your Honor, this is Antreon Coleman and 17 CF 1004, 25 CF 2019.
Are you on both? Well, doesn't he have like another case too that wasn't listed for you?
No, I think he just has those two. That I'm aware.
Okay. Maybe I confused him with someone else. I just wanted to make sure that we got all your cases while you're here. There was someone who was listed as representing themselves, I think. All right, go ahead with Mr. Coleman's cases.
You know, we have a deposition set June 16th. I ask for continuance.
Oh, okay, now I found it is. Similar first name as yours, but, all right, depots are what date?
June 16th.
June 16th. All right, so you're asking for June 24th?
Yes, sir.
All right, June 24th at 9 o'clock, Mr. Coleman, we'll see you back on that date. Sorry for the mix-up.
Yeah, it's up to you. Just Jacob Gabany, 25 CF 380, 25 CF 2031. Your Honor, I'm asking for a continuance. I should have a transcript this week from the pretrial detention hearing and working on a motion to suppress. So I'd ask for continuance on this.
That's without objection, Judge.
All right, June 24th, 9 o'clock for Mr. Gabany.
Yes, sir.
Let's make sure that gets filed ahead of time.
Yes, sir,
I
I'm
know
gonna get it filed as
transcripts
soon
are
as-
coming a little bit slower than we would like, but let's
As soon as
make
I get it,
sure.
I'm gonna get it filed, Your Honor.
All right, appreciate it, thank you.
Robert Jones.
Your Honor, next up is Robert Jones, in 24 CF 2083 and 24 CF 2735. I just need him to sign this real quick.
Okay.
We went over at the jail, I just need him to sign it. No, you are.
Jones.
Mr. Jones. We'll see. We'll see. We'll see. There's a plea, I don't know what it is yet.
If I may approach you with a plea and score sheet.
Yes, please. Thank you.
Your Honor, it'd be a plea as charged to all counts except for count 1 and 24 CF 2735 will be an amended charge of trafficking in methamphetamine, 14 to 28 grams, which is a 3-year minimum mandatory.
Okay. Does that not change the offense level for the primary?
And I think it's the
Doesn't.
same level.
I just want to make sure.
Yes, sir.
Just because he scores 39.525, so even though it's a 3-year minimum mandatory, it's still also a downward departure, right?
Yes, sir. A slight one.
I mean, by a couple of months, but I
Yes,
still
sir.
have to say all the
Yes, sir.
same things that I would say if it were
Yep.
cutting it in half.
And that would be a product of a negotiated plea, Judge.
Okay, just wanted to make sure I got everything on board.
Yes, sir.
All right, Mr. Jones, can you raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Robert Zacchaeus Jones, October the 2nd, 2001.
All right, and you're here in 24 CF 2083 and 24 CF 2735. In the 2083 case, you're charged with fleeing or attempting to elude, third-degree felony, punishable by up to 5 years in state prison, and driving license suspended, second-degree misdemeanor, punishable by up to 60 days in county jail. In 24 CF 2735, it's trafficking in fentanyl, which is going to be, according to the plea, changed to an amended count of trafficking in methamphetamine, 14 to 28 grams. That is then a, what level felony?
First degree.
It's still first?
Yes, sir.
Okay. First-degree felony punishable by up to 30 years in state prison. Count 2 is sale, manufacture, and delivery. Is that also of methamphetamine?
No, it's cocaine, I believe.
Okay. That's a second-degree felony, 15 years maximum. Count 3, fleeing or attempting to elude, third-degree felony. Count 4, possession of controlled substance, third-degree felony. Count 5, tampering with evidence, third-degree felony. Count 6, possession of more than 20 grams of cannabis, third-degree felony. All those third-degree felonies are punishable by up to 5 years in state prison. 7 is drug paraphernalia. 8 is resisting without violence, both first-degree misdemeanors punishable by up to a year in county jail. Count 9, driving on suspended license, 60 days jail. Count 10, reckless driving, 90 days jail max. You understand what you're currently charged with, Mr. Jones? Okay, Mr. Jones, I've got a plea and sentencing agreement between you and the state that would call for you to plea to an amended charge of the trafficking in methamphetamine, like I previously stated, otherwise as charged. In return of being adjudication of guilt, so that's 1, 2, 3, 4, 5, 6, 7 felony convictions. Do you understand that? It'd be time served on the misdemeanor counts. On the felony counts, it would be 3 years Department of Corrections with a 3-year minimum mandatory in a 24 CF 2735 count 1. That's the amended charge of trafficking in methamphetamine. It'll get credit for all time served. $1,040 court costs, $50,000 fine in 24 CF 2735, $548 in court costs on the 2083 case. All cases and counts to run concurrent. All costs will go to judgment. Did I miss anything? All right. And as stated, this is a downward departure. As the state has announced, it was based on it being an uncoerced, legitimate plea bargain. Mr. Jones, have you had time to go over this with your attorney?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation in this case?
Yes, sir.
Are you currently currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything other than the terms of the agreement that I just read?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind on any of these charges?
Yes, sir.
And do you understand that you're giving up your trial rights, which are on page 2 of that agreement that you said you understood and signed?
Yes, sir.
All right, you understand that you're waiving all potential defenses that you may have? And do you understand that if you're not a U.S. citizen, that this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the fleeing or attempting to elude 2 counts of driveway license suspended, trafficking in methamphetamine, sale, manufacture, deliver cocaine, another flee or attempt to elude possession of controlled substance, tampering with evidence, possession of more than 20 grams cannabis, possession of drug paraphernalia, resisting without violence, and reckless driving?
No contest.
I'll accept your no contest plea as given to all counts, including the amended trafficking in methamphetamine. According to the plea agreement, I'm going to adjudicate you on all counts, time served on the misdemeanors, on all the felonies, 3 years Department of Corrections with the minimum mandatory on count 1 and 24 CF 2735. You'll get credit for all time served in both cases. In the 24 CF 2735, it's a $1,040 court cost and a $50,000 fine. $548 in court costs in 24 CF 2083. All cases and counts to run concurrent in all your cost to judgment. It's a downward departure based on uncoerced plea agreement. He scored 39.525 months, so it's only a couple of months difference. Mr. Jones, I do need your fingerprints, and you have 30 days to appeal the judgment and sentence of the court. All right, thank you. Steve, I've got an interpreter on now, so once Ms. Dudley finishes, if we can bring Mr. Cruz's case back up, Garcia Pena. Mr. Cruz, we've got an interpreter that's going to be on Zoom, and we'll call them. I'll call you back up once we finish with this lawyer, Ms. Dudley.
No, this is Trace Marshall. This is Trace Marshall, 19 CF 1607, 23 CF 1981. I want to leave it for docket day.
Okay.
I'll probably have to have somebody come cover. I have depots in Walton County.
Okay, what's going to happen on docket day?
It should be resolved. It should be a plea.
Okay.
We got a minute offer. We've been back and forth with the state, got a updated score sheet, based on some stuff being removed. I just want to make sure I go over all the terms with him, of the probation part of it.
Okay.
So that we have it all nailed down.
I'm going to list it as plea or trial, because I announced it as last continuance last time. His case is from 2023. All right, we'll see you back.
Can we just leave it set for tomorrow? I'll go talk to him this afternoon. He said we can get it done tomorrow.
Do you have any issue with that?
No issue with that, Judge.
Okay. All right, so I won't put it on the trial docket unless it doesn't plea tomorrow, but otherwise it's going to be resolved this time around. All right, 4:30, is that at 9 o'clock?
Yes, sir.
Is that what you're asking for? All
Yes, sir.
right, tomorrow at 9 o'clock for a plea.
Thank you, Mr. Oberliesen.
Every time.
Next I have is Adam Sheets, Your Honor.
Mr. Sheets.
Your Honor, I asked for the continuance in this case. I'm gonna work on a motion to dismiss.
Motion to dismiss?
Yes, sir.
Without objection, Judge.
All right, Mr. Sheets, based on your attorney's request, June 24th, 9 o'clock for your next pretrial. We'll see you then.
I believe that's all I have, Your Honor.
All right, thank you.
Mr. Garcia.
Word reference.
All right, good morning, Ms. Cardenas, can you hear us okay?
Good morning, yes. Can you hear me?
Yes, I can. Thank you for jumping on so quickly. We didn't know we needed an interpreter, but I'm glad you could do it so quickly.
No problem.
All right. Do you swear, can you just raise your right hand, do you swear for him to interpret accurately to the best of your ability?
I do.
Okay. All right, this is Raul Renier Garcia Pena, case number 25 CF 485.
Estamos en el caso del señor Raúl García Peña, caso 257485.
He's here with his attorney, Mr. Cruz, who's on Zoom.
Con su abogado presente, el señor Cruz, que está presente vía Zoom.
All right, Mr. Cruz, what are you asking to do today? You're muted, Mr. Cruz. There you go.
Yes, sir. We've filed a motion to withdraw, and we're seeking leave to withdraw from the case, Your Honor. Additionally, we at first appearance, he was appointed the public defender, so we didn't even get notice of this hearing. Thankfully, my colleague appeared before you on Monday and you mentioned it. That is the only reason why we're here, which is why
Okay.
no mention was made for the interpreter.
All right. Well, thank you for explaining that, Mr. Cruz. All right. Go ahead and interpret, Ms. Cardenas, I'm sorry.
Señor, el abogado Cruz presentó una petición para retirarse de su caso. Está mencionando que en su primera comparecencia se le nombró un abogado de oficio que no recibió notificación de la fecha de hoy, por lo cual no se había notificado que usted habría necesitado un intérprete hoy.
Mr. Garcia Pena, do you have any objection to Mr. Cruz withdrawing from your case and me ordering or appointing the office of the public defender?
Señor García Peña, ¿usted se opone a que el señor Cruz se retire de su cargo y que el juez le nombre un abogado de oficio?
No, solo necesito un abogado.
No, I just need an attorney.
Okay. All right. I'm going to sign the order on the motion to withdraw Mr. Cruz. I'm appointing the public defender to represent you.
Muy bien, señor Cruz. Voy a firmar la petición del señor Cruz para retirarse de su caso y le voy a nombrar el defensor público.
Okay.
Thank you, Your Honor.
All right. Thank you, Mr. Cruz. You're free to go. Mr. Garcia Pena, this is Mr. Maddox from the public defender's office.
Señor García Peña, este es el señor Maddox de la oficina del defensor público.
All right. You were just appointed.
Yes, Your Honor.
What would you like to do with this case?
We're here for arraignment today or at his pretrial conference?
This is his pretrial conference.
Okay, Your Honor, I'll continue the case. I've got to get up to speed on it, Your Honor. Does the state, what is the offer in this case?
Give her time to interpret.
Oh, I'm sorry, yes.
El señor Maddox ha sido nombrado su defensor público. Él está pidiendo aplazar el caso para ponerse al corriente con toda la información y estamos preguntando si la fiscalía tiene una oferta para usted. Vamos a escuchar si la fiscalía tiene una oferta.
The state's offer was a withhold of adjudication, court costs, 2 years probation, and substance abuse evaluation and treatment.
La fiscalía le ofrece fallo condenatorio de culpabilidad, gastos judiciales, 2 años de régimen probatorio y que sea una evaluación de sustancias.
Mr. Garcia,
¿En qué se basa la evaluación de sustancias?
What is this substance abuse evaluation? What does that consist of?
So essentially, probation would walk you through.
make sure you're saying it so she can hear it and translate it to her.
Essentially, probation would walk him through it, but what he would need to do is go in and complete an evaluation, and then if there's any recommended treatment, follow up with that treatment. So they may determine that he has no substance abuse problem, and therefore no treatment would be needed, but if they do determine there's an issue, then he would need to follow up and get treatment. Usually that's done by Bridgeway.
Esencialmente lo que pasa es que la oficina del régimen probatorio lo va a ayudar a usted a realizarse una evaluación para tratamiento de abuso de sustancias, lo cual significa que usted pueda que le recomienden algún tratamiento, pueda que no le recomienden ningún tratamiento, y si hay algún tratamiento que se le recomienda, nada más le pedirían que usted lo complete.
Okay, sí, entiendo. Okay. Your Honor, could we put this, just to see if there is a possibility for resolution, could we put this on docket day for 5-4? Well, actually, no, I won't be able to arrange for an interpreter to go out to the jail. Let's just leave it for the next pretrial conference. We'll arrange for an interpreter to go out with us to the jail and speak with them and then see if we can resolve the case, Your Honor.
El abogado estaba pidiendo inicialmente cambiar su caso, aplazarlo para el día 4 de mayo, pero no cree que va a poder ir a la cárcel con un intérprete para esa fecha. Entonces para la próxima fecha de conferencias previa al juicio, para que se quede para ese día y él pueda arreglar para que un intérprete venga a verlo a la cárcel con usted. ¿A usted?
Assign offer. Estoy de acuerdo con la oferta de la fiscalía.
I accept the offer from the state.
Okay, you can do that, sir. He can plea at any time, but I have not looked at the discovery. I know nothing about this case, and it is a felony charge, so it's serious.
It was a withhold, right?
Usted puede su declaración en cualquier momento, pero yo nada más quiero avisarle que yo no he visto ninguna de las pruebas en su contra. Este es un caso serio.
José, la fiscalía dijo withhold adjudication, so no me va a quedar la felonía en el récord.
I think I heard the state say withhold of adjudication, so I wouldn't have this on my record.
Well, you wouldn't have a felony conviction on your record. You would still have a felony charge that shows up in background checks and on the clerk's website. It's just that you wouldn't have a conviction on the felony charge.
Sí, lo que eso significa es que usted no tendría una condena de un delito mayor en sus antecedentes, pero aún así esto sí aparecería en sus antecedentes o en la página de la secretaria judicial, o si alguien le revisara sus antecedentes, sí aparecería en sus antecedentes.
All right, hold on. Let me make sure I correct something.
Yes, Your Honor.
Although the state considers a withhold not a conviction, the federal government and federal courts would consider a withhold on a state court case to still be a conviction in most cases. So, for purposes of immigration, if that's an issue, the immigration court would consider this a felony conviction. I have to make sure you understand that.
Thank you, Your Honor.
No, tenga en cuenta que aunque se le retendría el fallo en el gobierno federal, esto sí lo tomarían en cuenta para usted. Un delito como este sí lo tomaría en cuenta el gobierno federal para propósitos de inmigración, nada más para que usted lo tenga en cuenta y entienda usted eso, si eso es lo que usted está pensando.
I know.
Okay. Well, if y'all want to write it up and bring it back, but I'm not sure, Ms. Cardenas, if you have any other time later today to potentially be present for purposes of accepting a plea, I need a written form done.
Yes, Your Honor.
Si su abogado quiere redactar y preparar el documento para su declaración, podríamos hacerlo más tarde.
Yes.
All right. Ms. Cardenas, what would work for you as far as time today to come back?
Anytime works, Your Honor. I have a meeting from 11 to 12,
Okay.
which I would be tied up at that time, but anytime after that is fine.
All right. Can we set you up for 1 o'clock? Would that work?
That works.
Okay. All right. That's when we'll
Vamos
come
a
back.
regresar a la 1 de la tarde entonces para tomar su declaración.
Okay.
All right. Thank you again, Ms. Cardenas. We'll see you at 1 o'clock via Zoom.
No problem.
All right, Mr. Garcia Peña, we will see you at 1 o'clock for your plea.
Muy bien, señor García, lo veremos a la 1 de la tarde para que presente su declaración.
Okay, thank you.
All right, thank you.
All right, thanks, Your Honor.
Gracias.
Thank you, sir. Thank you. Yes, let's do Mr. Tony. Are you ready, Mr. Williams, to handle Mr. Barr's case? Yes, sir. Okay, so let's do Mr. Tony's cases, then Mr. Barr with Mr. Williams, then I'll bring Mr. Ramey in.
Good morning, Your Honor.
Morning.
State of Florida versus Josh Ramsey in 2025 CF 1091, 26 CF 77, CF 77. Come on, Josh.
I appreciate you not bringing up my Pistons again, Mr. Tony.
Your Honor, we want to leave this set for a docket day with either a plea or a continuance.
Okay, and that's for both cases?
Yes, Your Honor.
All right, May 4th, plea or continue, 9 o'clock. Mr. Ramsey, we'll see you back on Monday. All right.
I'll come see you.
Williams.
Is that Byron Williams?
Yes, Your Honor. State of Florida versus Byron Williams, 2025 CF 1958 and 2025 CF 1131. With regards to Mr. Williams, Your Honor, I think we have a tentative agreement, but I hadn't had an opportunity to talk to him about it. So here again, I would like to have it on docket day with the opportunity for a plea or a continuance, but I'm about 90% sure it's going to be a plea.
Okay.
The state has no objection to that.
All right, May 4th, plea or continue, 9 o'clock. It's in 25 CF 1131, 25 CF 1958.
Thank you, sir. That's all I have.
All right, thank you. Mr. Williams with Mr. Barr.
Your Honor, we're back with Mr. Barr. I believe you have the case numbers, or would you like me to repeat them?
If you've got them, I'm
I've got them.
switching over right now.
22 CF 1851, 23 CF 1016, 24 CF 2616.
Okay.
And Your Honor, last time we were here, we said we had just a few more depositions to do. We've got everything complete except one deposition, which is scheduled for June the 16th at 2:30 in the afternoon.
In which case is that for?
That's in the driving case, the main case, Your Honor, 2616.
Okay. You said it's June 16th?
June 16th, yes, Your Honor.
All right, so what are you asking for?
A continuance and, well, that June 24th will be right after that, but that's it should be, we should have everything complete by then.
State? Who's handling Mr. Barr?
Miss Leone
Okay.
is,
I only saw one case number listed, I just want to be sure. The state has no objection, Your Honor.
So I called this last continuance last time. So I'm certainly calling it last continuance this time.
yeah, Your Honor,
I understand another deposition has to be done, but, I mean, there's the VOP, but then the one case is from May of '23, so it's about to hit 3 years old. And the '24 case is from November of '24, so that's a year and a half old, right?
yes, Your Honor, the one we're deposing was previously a confidential source. They finally revealed him, and that's why we got it set up.
I understand. But one of the cases is going to need to be set up for trial, or the cases will need to be resolved next time. June 24th, 9 o'clock. Anything else from Mr. Barr?
That's it, Your Honor.
All right.
That's it, Your Honor.
Thank you, Mr. Barr.
Thank you, Your Honor.
I'll be out to see you week after next. And I believe that's all the cases I have, Your Honor.
Thank you, Mr. Williams. Have a good day.
Thank you, sir.
All right, so we have Mr. Ramey. Let me bring him in. Morning, Mr. Ramey. Can you hear me okay? Mr. Ramey?
Can you hear me, Your Honor?
I can hear you. Now I can see you.
Good morning,
So you
Judge.
went from the front stairs of the Supreme Court. No, I can't tell quite where you're at. Looks like some sort of large conference room.
Just change of venue, Judge.
Okay. Did you file a proper motion for that, Mr. Ramey?
Unfortunately, I didn't, Judge.
Okay.
I thank the court for mercy.
All right, I'll allow it. All right, Mr. Brake is here, 26 CF 151.
Judge, thank you. Russ Ray on behalf of Noah Brake. We have deposition scheduled on June 25th. If you have a pretrial after that, I'm hoping most of the witnesses show up and we can get a lot done on that date.
All right, so then our next pretrial docket is the day before that, June 24th. Do you want to come back on the 24th? Or should we look into the August dates?
I would prefer the August date, Your Honor.
All right. Do you have those off the top of your? Let's see. August 26th. All right, it'd be August 26th at 9 o'clock. Obviously, if something changes in the case, y'all need to bring it in front of me sooner. You can do that, but I don't want to necessarily set a pretrial conference date that's before your depositions.
Yes, sir.
So if something comes up, you need to address any motions or any, or a plea or anything like that, set it on any one of my other dockets.
Yes, sir, very good. Thank you.
All right, you understand that, Mr. Brake?
Yes, sir.
All right, thank you. We'll see you back
See you
then.
soon, Noah. Judge, I have two other cases on the docket today.
All right, here comes Mr. Myrick is up now. Anthony Myrick, 25 CF 1952.
Yes, sir, and Mr. Myrick's case,
I think we're set for a bond motion tomorrow, are we not?
got a bond motion at 2 o'clock tomorrow, and we have depots scheduled on June the 11th.
All right. Why don't we just go ahead and set it for tomorrow? We'll address it further for the bond motion.
Yes, sir. Can I ask you a question on that, Your Honor?
Yes, sir.
I have a flight to catch at 4 o'clock to see one of my doctors in Tampa. Is
Okay.
it possible we could take that at 2 so I can make my flight?
Okay. I think we can do our best.
It'd be a short motion.
Changing venue again, I guess. All right. Let's make sure we try to bring Mr. Myrick up as close to 2 o'clock as possible. All right, Mr. Myrick, we'll see you tomorrow for your bond hearing.
And my last client, Your Honor, is Malachi Watkins, who's in custody. Your Honor, in Mr. Watson's case, we've been trying to get depots set. The state attorney invited me to send her a couple of dates. We sent those dates for June 9th and June 10th. Don't know if those are going to work for the state yet, waiting on a reply.
Whose case is this for the state?
It's mine, Your Honor. I know June 10th isn't going to work because I'm with Judge Clark. Mr. Ramey, if you'd send us some more dates, please. Unfortunately,
the
that's our
ninth.
South End trial, or South End week.
The 9th doesn't work either.
Let me just quick check. Let's make the 9th work.
I have 2:30 to 4 if you have the afternoon.
2:30, got it.
Okay.
I'll confirm that in an email, Your Honor. Depots are set.
Okay. Depots are going to be set for June 9th. We'll come back for a pretrial conference June 24th at 9 o'clock. All right, thank you,
Thank
Mr.
you, Your
Watkins. Is that all you have, Mr. Ramey?
I believe so, Your Honor. Thank you.
All right, thank you.
Great to see you, sir.
You too.
See you tomorrow. Bye-bye.
They're working on bringing Mr. Nopes's out, but I have a pro se Antirius McLean right now.
Okay, let's just bring up Mr. McLean and see what he wants to do. Hold on just a second, Mr. McLean, and find your case. There it is. All right, so this is Antirius McLean, 26 CF 248. Mr. McLean, you're currently not represented. Are you planning to hire a lawyer, or would you like me to appoint you one? You plan to hire one?
Yes, sir.
Have you spoken with one yet? Okay, and when do you think that might be done? Later on this week? I'm repeating all your answers because I can't hear you very well. Just
Later on this week.
make sure you're speaking onto the microphone. So what would you like me to do with your case in the meantime? I can do basically one of two things. I can set you for Monday just to see where things are at.
Set it for Monday.
Just to make sure you have an attorney here, and then if you don't, I can talk to you again about whether or not you want me to appoint one for you. Or I can pass it to the next pretrial, which will not be till June 24th.
We work for Monday.
Monday? Okay. Let's put Mr. McLean on Monday, May 4th at 9 o'clock for purposes of status on his attorney. All right, we'll see you back that date, sir.
We've got Mr. Notes lined up. The first one out goes to Cunningham.
Judge, I've got Mr. Cunningham, 26 CF 321. Judge, we're asking to continue this. We're trying to get the depots scheduled.
Hold on, let me get back to you, Mr. Notes. All right, this is the first time up. It's a brand-new case, so let's go 6/24, 9 o'clock for Mr. Cunningham.
Then,
I'm sorry, Matt, purple shirt, are you taking pictures? Are you sure? I didn't just see you point your camera at the defendant? All right. This is not a place for photography or taking videos. Okay.
Oh, I got you.
Your name is? Sanders, come on out.
Judge, next person I've got is Colby Sanders. Judge, we just got a stack of discovery that we downloaded and sent to our expert that we hired in this case. So I'd ask to put it on June 24th.
That's the first time up, June 24th, 9 o'clock. See you back on that date, Mr. Sanders.
Judge, the next case I've got, and actually, Lisa Rivers also is representing him on a number of cases, is Ralph Thompson. The state and I are still working out the details, so I just need to pass him for a little bit. I'll bring him back this afternoon.
Later today?
Yes.
Ms. Rivers?
Yes,
You
Your
agree with that?
Yes, Your
Okay. All right, Mr. Thompson, they're going to talk to you some more. They're trying to work out the final details, it sounds like. We'll bring you back later today.
Judge.
Thank you.
Next case I've got is Taquan Watson.
Mr. Watson.
Judge, Mr. Watson, 25 CF 987. We've taken some depositions. We were not able to get the alleged victim served, and so we've got to reschedule him along with 2 or 3 or 4 other witnesses. So I think we've cleared the date. The notice is being prepared, so we'd ask to put it on June 24th.
All right,
Without objection, Judge.
June 24th, 9 o'clock. All right, thank you, Mr. Watson. This case is getting to be a year old, so let's make sure that's happening. I know you're trying to serve people, but if they don't show up or want to be served.
I'm going to send an investigator to serve.
Okay, thank you, Mr. No. Is that everything?
I'll come back and talk.
I'm Mr. Thompson.
I also have Mr. Brewster. Brewster?
Bruce.
No.
Stephen Brewster.
Your Honor, on Mr. Brewster, the issue here is we'd filed a transfer, and I guess the order only included one of the 3 cases that were up here, so we will resend it and send you an updated order, Your Honor, to make sure that the other 2 can go down to the south end as well.
Okay. All right. Yeah, it looks like there's a bunch of other case numbers on the report I'm looking at. All right, just send me over an order. I'll get that signed. Who's that going to be in front of? Judge Stone. Okay, we'll get you a new date. Let's put it on ours for 6/24 just for status to make sure it gets resolved, but otherwise it'll end up getting sent over to Judge Stone in Division 2.
Thank you, Your Honor.
Thank you.
Anybody lined up, but Gregory Austin is telling us that was continued.
It was continued already. I signed the order earlier this week. I think it was Monday. 6/24, 9 o'clock. Gregory Austin. Parnell. Not that I know of. Could be wrong. Oh, yeah, we talked about it on Monday with his other case, so it's set for 6/24 at 9 o'clock. For some reason, one of his cases didn't get put on the right date. I think he went into custody between the two. All right.
Your Honor, this is Bradley Anderson. He's got two cases on today's docket. In case 25 CF 954, we're going to announce plea or trial.
State's ready.
Which case are we talking about for the trial?
That's the 954. That's the fleeing case.
954?
Yeah, he does have 955, but
That's what I didn't know if you were trying to set both or just one.
They were on the same date, but the state would move forward on the high-speed fleeing and eluding instead of the possession of controlled substance.
So plea or trial?
Yes, sir.
All right. All right, Mr. Anderson, we'll see you back on Monday. That's docket day at 9 o'clock. Put it down as plea or trial.
Bradley, I'll see you on Friday. Your Honor, this is Kristen Barnes. The situation on Miss Barnes, Your Honor, is I'm expecting that she's going to plead into mental health court next Wednesday. If we could just continue these to the 6/24 docket as a control date.
Without objection.
You say Wednesday next week?
That's my understanding. I've been talking to Ms. Sharpless about it.
That's what, May 6th? All right, Ms. Barnes, if you don't end up in mental health court next week, we'll see you back on June 24th. And if anything kind of doesn't work out well with that, you need to come in earlier, just try to set it on an earlier court date.
Thank you.
But 9/24 for
Kristen, I'll see you probably Monday
control.
afternoon. Your Honor, this is Mr. Byrd. We are waiting to depose there are two troopers involved in this matter. Also, Mr. Byrd has a Phoenix House application pending. Once we get those depositions taken and an answer from Phoenix House, we'll be prepared to resolve this. I would ask the court for a one-cycle continuance, expecting to set it for trial, plea or trial next time. This goes for any case I have. If we reach an earlier resolution, we'll put them on an earlier docket.
As Judge Maney always used to say, the court is always open for a plea.
That's what I tell clients that all the time. And so Your Honor's aware also, I've been making it clear to all of my plea or trial clients that Monday is the last negotiated plea day, so.
And I've announced that a couple of times
they're
during
all aware.
pre-trials.
Yes.
All right, so we'll put him on June 24th at 9 o'clock. But again, you can put it on an earlier date if you're ready.
Mr. Colley.
Your Honor, this is Tristan Cawley. Mr. Cawley was recently rearrested. We are going to ask the court for a one-cycle continuance. The situation with Mr. Cawley is he would qualify for drug court, so I'm going to talk to drug court, see if I could maybe have him evaluated. He does have a current 24-month plea offer. We do need to take the depositions. If we could ask for a one-cycle continuance. If he gets into drug court, clearly we'll go that route, I would believe, but.
Without objection, Judge.
All right, June 24th, 9 o'clock for Mr. Cawley.
No, Mr. Cook, we filed a waiver for Mr. Cook. We were just appointed to Mr. Cook's case. So I would ask the court for a one-cycle continuance. I did meet with him at the jail, explained we had just been appointed.
First pretrial.
Yes, it's his first time out.
June 24th at 9 o'clock.
Your Honor, this is Mr. Copland. Wait.
I'm sorry. My bad, Judge.
That's all right.
If we could leave Mr. Copland on for plea or continue on Monday. I've been talking with Mr. Sprouse. I think we're going to probably resolve this on Monday. So that's why I'm asking to put it over for Mondays. I expect a resolution.
Okay.
Without objection.
All right, May 4th, plea or continue. We'll see you back on Monday.
Cruz was the next one.
Correct. Mr.
He's
Cruz
already
was
been
already
continued to June 24th at 9 o'clock.
Your Honor, this is Mr. Kelvin Ford. Looks like on March 11th, Mr. Ford filed a document with the court. I did not receive it until March 30th. That raises Nelson hearing allegations. So I have not met with Mr. Ford. I was going to meet with him a couple days ago and saw this document. I don't know how the court wants to handle this, if it wants to put it on for Monday for the Nelson hearing or if it wants to do it now.
Mr. Ford,
Yes, sir.
how would you like to proceed?
I'm asking you if we could deal with my Nelson hearing. I would like to discharge my appointed counsel.
Okay, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Kelvin Lee Ford, 04/26/1999.
All right, and I read it's a one-page document that you sent over on March 11th. I reviewed that yesterday. What would you like to tell me as to why you think Mr. Klein should be discharged from your case? Speak into the microphone, please. Can you move it over for him a little bit, Mr. Kleins?
Oh, yeah, I'm sorry.
I write him. He never writes me back. I ask him to come see me. He never comes sees me. I've asked him to contact my mother to be a witness to subpoena her for depositions because she was there when I got attacked by this victim, and he has not made contact to her. He don't come see me, and I just feel as he's not representing me to the best of his ability, and he wouldn't be in my best interest. And I asked the man if I told him I need help, and he said that he asked me, do I believe in God? And that's the only way that, that I would be able to get help. And it's like I demanded upon speedy trial the last time I was at court on February 25th, and we went back on March 2nd, then set for trial, and he told me that, we're just going to ask for a continuance. I don't want a continuance. I was attacked, and I'm telling him that I'm attacked by this victim who has an outstanding warrant in Okaloosa County, and I'm telling him that I shouldn't be in jail. I wanted to go to trial, and he was like, oh, well, hopefully we'll have a resolution by April 29th, and he don't come see me. I just don't see eye to eye with him, and I would like to discharge him from my case. I don't want him representing me.
Okay, Mr. Kleins, any response?
Your Honor, as to contacting his mother, I have called her. I called her twice. She doesn't have her voicemail set up. So she's called my office twice. So if she doesn't have her voicemail set up, I tell this to clients frequently. Like, that's one of the big gripes that I have trying to call people on the phone is they either, their voicemails are full or they're not set up. So if she's not answering her phone, she's not setting up her voicemail, I'm not going to keep calling her every other day just to try to hopefully get her on the phone. As to trying to make contact with this alleged victim, my office has tried to contact her 6 different times through 3 different phone numbers, including phone calls and text messages. She can't, as a matter of fact, my investigator even confirmed through a records check that this is her phone, that this is a phone number that belongs to the alleged victim. So, and I did tell Mr. Ford that if we didn't get this resolved by this cycle, I'd be more than happy to file a speedy demand and go to trial. This allegation about telling him that believing in God is the only way, that's ridiculous because while I do believe in God, I don't think he's all that present in a courtroom, quite honestly. So I don't know what else he wants me to do. Mr. Ford is looking at a pretty gnarly score sheet here. He's got 2 violations of probation cases. I was more than prepared to file a speedy demand to get this to trial this cycle, but if he's claiming I'm not coming to see him and I'm not doing this, that, and the other, well, we haven't got the deposition scheduled yet, but I'd be more than happy to take this to trial without taking depositions. He's proposed pleading to misdemeanors. State's not going for it. I don't know what else he wants me to do, you know? I mean, I have tried to contact his mother. I've tried to contact the alleged victim. He's a violent felony offender of special concern. I can't get out on bond, so I can't file a bond motion. So,
All right, Mr. Ford, you raised your hand. Anything else?
Yes, sir. And the whole reason why, and another reason why I'm not seeing eye to eye with him, I've literally told him from the get-go about me being victimized. Even in my police report, the officers had documented my injuries when I told them that I was attacked by this victim because she was committing crimes and the police was looking for her. And I told her that I didn't want her at my
All
house.
right, hold on a second.
Yes, sir.
Hold on.
Yes, sir.
I'm just going to give you some, not advice, but advise you that anything that you say about the facts of your case, I'm not asking you any questions about it. Mr. Kleins has not asked you any questions about the facts of your case, so anything that you say can be used against you. The prosecutor's sitting right there, listening to everything you say. Everything in this room is recorded. So if you say something about the facts of the case, the prosecutor can go get a recording of today's proceedings and present it at your trial to your jury. Just want to make sure you understand that. You have a right to remain silent. You seemingly are making decisions to talk about this. I'm just giving you the advisement that anything you say can and will be used against you.
Yes, sir. I understand that. I just wanted to present it and let the court know what's really going on, you know. And I've tried to talk to him about it because the victim attacked me and
I understand you said that 3 times.
yes,
now.
sir. But it was all about because the police was looking for her. She robbed some place, and I didn't want it at my house because I'm doing good. I completed my substance abuse treatment out there on probation and everything. I was doing good, working, doing everything I needed to do to get off probation. And the only reason I'm here is because this girl lied on me because I didn't want her at my house anymore because the police was looking for her. She has a warrant right now in Okaloosa County, and I was attacked. I had injuries and everything, and I told the police that, and I tried to file a complaint, and they refused me, and that's what's really going on. And I've let him know the truth, and it's like he's not working for me. He's not trying to help me. I even demanded upon speedy trial. I want to dismiss him from my case. I want to discharge him and ask the court to appoint me a new counsel, please.
Okay. Do you understand that's going to delay the case?
Yes, sir. I understand that.
All right. Although I haven't found Mr. Kleins to be ineffective, you guys clearly don't have a very good attorney-client relationship at this point. I'm going to allow Mr. Kleins to withdraw from your case. Who's the next person to be appointed?
Mr. Cobb.
Mr. Cobb. All right, I'm going to appoint Jason Cobb to represent you. He's not here today. I'll put your case on June 24th at 9 o'clock, and he'll come out to see you at some point, and we can talk about what you want to do at that point.
Yes, sir.
Yes, sir, Mr.
And one more thing before I leave, can I address and ask? I've also asked for a copy of my discovery, to which I have yet to get a full copy of my discovery. I don't even have the victim statement. I don't have none of that.
You can discuss that with Mr. Cobb once he gets his hands on it.
Yes, sir.
You have to understand, as Mr. Klein said initially, once you file the motion saying you don't want him to be your lawyer anymore, he can't pursue your case the same. Hold on.
Yes, sir.
You always want to raise your hand, but you don't want to really listen to what anyone has to say, Mr. Ford. Once that happens, he has to basically stop, because if he does something towards your case and I ultimately find he shouldn't have been doing it, then that's a problem. So now that Mr. Cobb's been assigned to your case, appointed to it, he'll have to ask for discovery. I'm sure he will. It'll be sent over to him, and then he can bring you the copy.
Yes, sir.
Anything else?
No, sir.
All right, thank you. June 24th.
Thank you.
Your Honor, this is Mr. Kevin Forrest. He's got 2 cases, 25, 1675, and 1676. I would ask the court for one last continuance. I did meet with Mr. Forrest. I was not present when, maybe we approached briefly,
Yes.
Mr. Forrest.
All right, Mr. Forrest, we're going to put you on June 24th at 9 o'clock. I would expect if it's not being resolved next time around, it could be set for trial.
Yes, sir, thank you.
All right, thank you.
Your Honor, this is Mr. Jabari Fountain. I talked with Ms. Basso this morning. If we could leave Mr. Fountain on for plea or continue on Monday, we're trying to get this resolved. I know there's another case pending on the south end, but she's the prosecutor on the south end. But we're trying to see if we can get this case closed, knowing that.
Instead of transferring it?
Instead of transferring it, yes.
We'll talk about it.
Go ahead and handle the one up here.
Okay.
All right. So May 4th, plea or continue?
Yes, sir.
All right.
Yes, Frazier's on for tomorrow's sentencing, so.
So we're just putting this one with that?
Yes, Your Honor.
Okay.
Ms. Frazier will be here tomorrow for sentencing on the EOP. Your Honor, this is Mr. Grady. I met with Mr. Grady at the jail yesterday. If we could leave him on for plea or continue on Monday. The state has proposed a resolution here that we're halfway there. We've agreed to the number that the state is proposing. I don't know if we can set this, if we're gonna get it resolved on Monday, and if we don't, what we'll do is we'll set the VOPs for an evidentiary hearing on Monday. But we are working to try to get this resolved.
That's acceptable, Your Honor. If we don't resolve the new case, then we'll go ahead and address the VOP on the next evidentiary date. Shouldn't be too hard to do.
Okay. All right, we'll see you back on Monday, May 4th, plea or continue.
Your Honor, one issue I need to bring up, on today's docket, at least on mine, there's 28 CF 339 and 28 CF 400. That 400 case is showing open on the clerk's website. However, that case was consolidated into the 339 case on February 28, 2008. So I don't think that the 400 case should be open. It's been consolidated into the 339 case. I only
But
bring
if you
that
could
up.
go through the archives and find out what happened in 2008.
It is, well, I was there. So, yeah, it was consolidated, Your Honor.
It was
I had to go back and look myself, but that was consolidated. That was a case that I tried back then.
I think we can take Ms. Basso's word for it.
I can go.
I may have
find
been in court that day as well.
I'll find the
but-
documentation as well, Your Honor, but it should be in there. I'll
Okay.
just double check it for the clerk.
Thank you, Ms. Basso. All right, we'll see you on Monday.
Henderson.
Your Honor, this is Mr. Henderson. I believe this is his first time up. This is a trafficking case. I met with him at the jail. I only left him on today's docket because he wanted to get out of the jail, see something different. So if we could ask for continuance for Mr. Henderson, we'll get those depositions started.
Without objection.
Okay. You understand that, Mr. Henderson?
Is that me? Yeah. Okay, I'll come talk to you, okay?
All right, June 24th, 9 o'clock. He's in DOC.
So with Mr. Hernandez, Your Honor.
That's Giovanni Hernandez, 25 CF 584.
Yes.
Go ahead.
I have a telephone appointment with Mr. Hernandez next Tuesday morning. I've set it up with his classification officer. I do probably expect he's going to want to enter a plea on this. So if we could continue him to the 624 docket, I'll know on Tuesday whether or not he wants to enter a plea. If he doesn't want to enter a plea, then I'm just going to let the court do what it needs to do next time we have court. But
All right, thank you. We'll put him on for June 24th, 9 o'clock.
Your Honor, this is Tanner Johnson in 25 CF 1310. For this case, we're going to ask the court for a one-cycle continuance, and one of the reasons why is Mr. Johnson was recently arrested in 26 CF 781. That case is on tomorrow's pretrial detention docket. Mr. Williams is currently representing Mr. Johnson on that. I just talked with Ms. Rivers behind me. I believe the Public Defender's Office is going to make a oral motion to withdraw.
That's correct, Your Honor. The conflict still exists. I did discuss it with our supervisor and filed the appropriate paperwork. You should be getting some paperwork soon regarding the conflict. But the conflict still exists, so we cannot represent him.
I guess while we're here, Mr. Sheik, is the state going forward with the pretrial detention tomorrow?
It is not, Your Honor, and that's what we figured we could resolve that today. We're just asking for, in this case, 25 CF 1310, that the bond be revoked and that the court can give a bond in the other cases appropriately.
Okay, and that wasn't done at first appearance.
I do not believe so.
It was
I'm
requested.
looking at the.
Yeah, it was requested at first appearance.
What's that?
I said,
The
the state
bond?
did request to revoke the bond at first appearance. It's on one of the sheets in the first.
I'm wondering if it's just because there was a pretrial detention that the
Probably.
first appearance judge didn't do it for that reason. Do y'all want to handle the quick bond hearing for the purposes of the new?
That's fine, Your Honor.
Can you address that? It's set for pretrial detention, okay, so what the court's going to do, which could have been done, I'm not being critical, I understand why, with the pretrial detention, they left it for me to do, which I appreciate, actually. I'm going to revoke Mr. Johnson's bond in 25 CF 1310 based on probable cause finding in the new case, which is 26 CF 781. Mr. Klein is I'm going to grant the PD's oral motion to withdraw, but if y'all could follow up with a written, just so it's clear on the record.
Yes, sir.
And appoint you to the 781 case. Do you want to give any argument for bond on that case?
Your Honor, I mean, I would ask the court for $75,000 cash or professional bond. The police report references, I believe, a suspected weight of 8.6 grams, give or take.
6.8.
6.8, okay, well, okay, had the numbers right, just not in the
Okay.
right order. It's obviously a 7-year minimum mandatory that Mr. Johnson's looking at. The bond's been revoked in the 1310 case. I don't suspect that the state had made an offer to Mr. Johnson, but on the 1310 case, I'm assuming it's revoked at least for temporarily, for now at least.
That's correct.
So Mr. Johnson's not going anywhere no matter what, but I do understand the seriousness of the charge, and definitely if the 1310 case falls apart, I think there should be a bond reflecting the seriousness of the charge. So we just asked the court for $75,000 cash and professional bond at 26 CF 781.
State argument?
State would accept whatever the court decides on that one.
Okay. All right. On the trafficking charge, it'll be the $75,000 cash or professional bond, pretrial supervision with weekly call-ins, no possession of any controlled substances without a prescription. As far as the resisting and the, was it paraphernalia? Yes, resisting and paraphernalia, those will just be ROR. But he'll be continuing to be held on the 1310 case, based on the court revoking his bond. All right, anything else from Mr. Johnson?
If we could just put all these cases together and put them on the 624 docket.
All right, both cases will be, well, I still have to keep his 781 case on an arraignment docket.
Oh.
For purposes, since an information hasn't been filed. So he'll remain on the felony arraignment docket in the 781 case for May 28th at 1:30. Otherwise, pretrial conference will be June 24th at 9 o'clock.
See you, I don't know if I'll see you before your misdemeanor, if you have misdemeanor. See you.
Ms. Lamb.
Cancel.
Cancel the pretrial detention hearing for tomorrow. Did we have any others for tomorrow? Looks like that's the only one so far. There's one more?
I got one at 9:30 that I haven't been able to look at.
Okay, I haven't seen it yet. All right, this is Cassidy Lamb, 24 CF 1701.
So the situation with Ms. Lamb, last Thursday, myself, Mr. Maddox, Ms. Basso, and Mr. Campbell sat down together and started reviewing the cell phone download.
Mr.
During that
Campbell
download-
being,
Say that again?
who's Mr. Campbell?
Casey Campbell, with the IT.
Okay.
Head of the IT.
Okay, oh, from the sheriff's office?
Yes, Your Honor, he has
Okay.
actually had the evidence there for them to review.
Okay.
So during that review, there's a lot of text messages. We had talked about another report being written and potentially getting some of the text messages that they can give us, because there's some that they can't.
This has been discussed before.
Correct. And so what I would ask the court to do for Ms. Lamb is to continue her one last time. Did meet with her yesterday or 2 days ago at the jail, explained that this case is coming to a resolution soon. It's been 2 years almost since the arrest. So my intent would be to probably set this for trial next cycle if there's no resolution. Just this morning, I did receive Dr. McDonald's report, so I'll get it over to you. I was sitting right behind it. So we're gonna ask for one last continuance. I expect this to be clear trial next cycle.
The stay will be ready for trial. We're ready now, but we understand.
My only, and I've said this a couple times already, July, which would be the next trial docket, will only have 1 week for trials. And so I want to make sure y'all are
We'll defer
ready
to-
for that,
Yeah, we'll
as far as what needs to go to trial and what can go to trial. And I think I announced that back in December, but I'm just kind of reminding everyone every time we come back up.
And I get that.
Lance and I have a few actually that either need to resolve or will be a trial next cycle or whenever we fit in, but we're ready.
All right, I just want to make sure if it's a situation where you've got some you want to pursue, that need to get done that time, that you are prioritizing that.
Yes, sir.
All right. All right, June 24th at 9 o'clock. And we'll see if we can get a trial next time.
See you on Friday and give you that report.
Tomorrow.
Your Honor, this is Mr. Morrow. I met with Mr. Morrow, Monday, 2 days ago. Yeah. I met with Mr. Morrow on Monday. We both, I was a little disappointed in myself that I didn't ask to continue this last time he was in court at the time. There's a lot of moving pieces with Mr. Morrow's situation. I would ask the court to continue this.
You just got appointed to
I
it.
just got appointed like 2 weeks ago, I think. So I would ask the court to continue this to either the 6/24 docket or the 7/1 or 2 whatever it is. I mean, so I'll leave it up to the court on what date you want to put it on.
Is there something else that needs to be?
I don't think so, but this is a kind of a very unusual situation, and it's been kicked back from the appellate courts. I think, based on my conversations with him, that basically we're back at square one in the sense that everything's been kind of vacated. So I'll leave it on a trial docket if the court wants. I'll defer to the court. I've only met with him. I haven't started looking at the documentation and the appellate rulings and all that, so.
Just give me a call, Mr. Kleins, I can fill you in. It's not as hard as it sounds, honestly. Plus, he has charges in Leon County for the same thing.
Are those pending new
Yes,
charges?
Your Honor, he did that while I was in prison. Same thing.
All right,
So give me a call. We'll kind
June-
of help you sort it out and get you to square one.
June 24th at 9 o'clock for pretrial conference. Anything else for Mr. Morrow?
Thank you, sir.
All right, thank you. That's the case too, like, for some reason they sent over a VOP from Santa Rosa County to,
Yes, Your Honor, this is Mr. Knopfsinger in 23 CF 2422. This will be plea or trial for Mr. Knopfsinger.
Mr. Kleins, I'm sorry, I didn't quite hear the announcement.
plea trial.
That's what I thought. Okay.
State ready?
Sure.
All right. All right, we'll see you back on May 4th for
Your Honor, may I
docket
address
day.
the court, please?
Say again?
May I address the court?
Have you discussed this with your lawyer?
No, Your Honor, but I would like to seek adequate counsel.
Adequate counsel? Have you filed anything?
I have not yet, Your Honor.
All right, I'm gonna need you to file something in writing. We can address it on Monday, but you're gonna have to file something. Your case is,
2.5 years old, Your Honor. I've been here for 30 months.
say again?
I've been here for exactly 30 months.
Okay, so have you brought this issue up before?
I have not, Your Honor.
Okay, just give me a coming attraction. What's the issue with Mr. Klein's representation?
Failure to file motions that I have asked to file,
What motions?
evidentiary hearing, suppression hearing,
Specifically,
pressure on.
specifically
to sign
what?
plea,
Specifically on what?
evidentiary hearing on all the evidence, seeing the.
That's what trials are for. That's when the evidence has to be presented. What type of hearing are you asking for?
Suppression hearing, Your Honor,
Of what?
of all of the evidence
Based on?
on falsely, illegally obtained statements.
All right, put it in writing, Mr. Nussinger. Your case
How would I
is,
go about doing that, Your Honor, when I don't have the capability or the means to file a motion? Where do I file that motion?
with the clerk.
How do I get that information, Your Honor? I'm incarcerated, and I do not have means to file.
People file motions from the jail all the time, Mr. Nussinger.
Other
This is the
people.
first time you've brought up anything. I don't think, frankly, I've even heard your
This
voice
is the third
before.
lawyer that I've had during this whole entire case. None of them have been doing their jobs. I've been in the ECLC program for over a year, and I've asked Mr. Kleins to bring that up, and he has not.
What do you
I
think
have
that's going to
asked
change,
for-
Mr. Nussinger?
I don't think it will change very much,
So,
but.
see,
there are
that's the
simple
point.
things.
What do you want him to bring up that's going to make any difference in your case as far as what we're doing here? You're either gonna, they've given you a plea offer. We talked about it last time. If
I
you
have
don't,
gotten no official
Mr.
plea
Nussinger,
offer.
you've interrupted me 3 times in a row now. I'd appreciate if you don't do that.
Apologize, Your Honor.
You've been given a plea offer, it's been conveyed, it was discussed last time. If you're not willing to take it, you can set your case for trial. However, if there's some motion that you think needs to be filed, you have to tell me what it is. You've never done that up to this point, because I need to know, and Mr. Kleins needs to know, so we can respond to those things in a timely fashion. As you said, you've been here for 30 months and you haven't brought this up yet. So what exactly are you asking him to suppress and why? Because Mr. Kleins can't file motions unless he has a good faith basis to do so. Otherwise, he'd be committing a violation of his ethics. So what specifically would you like him to file?
I know exactly what it is, because I'm not a lawyer, so I don't know exactly what it'd fall under.
Well, I guess
But I do
that,
know that I do not have faith in Mr. Kleins to represent me as a lawyer.
based on what? Mr. Knopfsinger, based on what?
As I stated, I would request adequate counsel. He has not
You have to
filed
tell me how he's been ineffective in some way. That's why I keep asking you the questions. What has he failed to do for you? Other than set a quote-unquote evidentiary hearing, but you haven't told me on what topic. I'm still awaiting a response. I just say that for the record because it's been some time and you haven't answered yet. What is the issue, Mr. Knopfsinger?
I haven't actually gotten an official plea offer, and even in the last court hearing, or last time we were here, there was, what the state was saying and what Mr. Klein was saying were not the same thing.
Okay, Ms. Basso, what's the
So,
state's
I
plea
don't even
offer? I
know
believe it
actually
was discussed at the last court hearing.
It was 50 years, but we'll revoke that now.
Under what grounds?
The state can revoke their plea offer at any time. It was discussed last time, it was 50 years, which I think was 25 years on each count to run consecutive.
Your Honor, it's actually punishable by life.
I understand, I think, but
Yes.
that's the way it was talked about last time.
Yes.
That offer, Your Honor, was relayed to Mr. Knopfsinger at the county jail on February 11th.
Okay, and it was talked about in court because I know about it, which is not normal, but it was discussed on the record last time.
So just to clarify the record, because it sounds like this is going to need to happen, there is a suppression issue on statements that Mr. Knopfsinger made to Investigator Garrett. I have already talked to the state about that and told the state if this moves forward to a trial, I will file a motion to suppress the statements, specific statements that were made to Mr. Garrett. The problem is that Mr. Knopfsinger made other statements on jail phone calls that I don't have any basis to suppress, to other individuals that I don't have any basis to suppress. So that's the only motion that we've talked about.
When are we going to have the suppression hearing on what was said to Investigator Garrett?
Well, when I talked to Ms. Basso, the issue basically is that these statements were made. The issue is that Mr. Garrett kept saying, you're not in custody, you're not in custody. Well, there was a significant display of force at that time. And I talked with Ms. Basso and said, look, I think that I can suppress these. She at one point had told me, file the motion, let me see the case law, I'll probably stipulate to it, and not introduce these particular statements that were made in the presence of Mr. Garrett or to Mr. Garrett. But the issue is that there are other statements that I can't suppress and that I have no basis to file a motion to suppress on.
Well, but doesn't Mr. Knopfsinger need to make decisions based on what the actual evidence is until there is some stipulation or a motion's been filed and ruled upon by the court?
And I thought about that this morning, and I'm going to get the motion filed tomorrow because I've got quite a gap in my time tomorrow morning between my morning docket and my afternoon docket.
I understand.
So that motion will be filed, but I expect it'll be stipulated to. We've tried to have a mitigation report done. We had to abandon that for reasons I won't disclose. I don't know what else he wants. There's no basis to suppress. I know his previous counsel had already requested and the court denied a ability to depose the alleged victims in the case. I don't know what else there is to do. I mean, he's been aware of this offer since at least February 11th. It's an offer that was made earlier this year. It didn't even exist last year. I've met with him at the jail. I know he's in the ECLC, and I have been asking, is Miss Dana going to send me a letter? And I've talked to her, and she has not sent me a letter, so I'm taking that as she doesn't want to provide a letter. Being in the ECLC program is not going to matter one bit to how this case proceeds. You know, I have relayed counteroffers to the state that Mr. Knopfsinger will plead to anything, any first-degree felony that is not one of these charges. The state won't agree to that. I have proposed every counteroffer Mr. Knopfsinger has given to me, and they have all been shut down. So I don't know what else he expects from me, honestly.
Was there a written order on the denial of the motion to depose minor children?
I don't believe so, Your Honor. I'd have to go look.
And it was apparently heard on September 5th of 2024 before I took over the division. That's why I asked, because I would have written an order.
Normally the defense would prepare those, Your Honor, so. And
I
think it was a different attorney at the time. I can go back and wander through the court file and see if I can find anything, Your Honor.
I don't see a written order. All right, Mr. Knopfsinger, I'm going to keep your case set for trial. Mr. Klein's filing any motions that you need to file. If there's a stipulation, that can be discussed on Monday. Otherwise, we can potentially hear it on Friday at jury review. You know, it's not my preference to do it at that point, just for time purposes. But that can certainly be done next Friday, which is what, the 8th?
Your Honor, at this time, I will be seeking private counsel. I request adequate time to find one.
At this point, unless you've got other counsel to take over the case, I'm setting your case for trial.
I'm in the process of acquiring a private lawyer, Your Honor.
Well, then we'll see them on Monday.
Just to be clear, I will not see Mr. Knopfsinger on Friday because there's a pending potential Nelson issue. Like, I mean, still file a written motion. I don't think it would be appropriate for me to go to the jail and talk to him.
Are there any other issues that you think he needs to address, Mr. Knopfsinger? The only thing you've brought up so far is a motion to suppress. We've addressed that.
I've also requested him to file a 3810, which is to find you, Your Honor, prejudice against this case due to you did my dependency hearing.
And I brought that up a year and a half ago when I took over your case,
I
right?
had mentioned it to Jennifer Flowers, who's my lawyer at the time, and she had agreed with me, but then she took a different job, I believe.
Okay,
From
have
that
you
point-
attempted in the, over a year since, asked for that to be done?
I had a lot going on in my personal life, Your Honor.
That's not an answer to my
To
question.
try to trust my lawyers and to be able to.
Have you talked to Mr. Kleins about filing a motion to disqualify the court?
Yes, Your Honor, I have.
Okay, Mr. Kleins.
Yes, on Monday is when he brought it up. And those motions are very time specific. They have to be made within, what, 10 days of knowing or learning about?
I think it's 30 days, but, I can't comment on those. That's the whole point, if you read the rule. I can't comment on whether or not, but I brought this to the attention of everyone on virtually every case that I handled any sort of issues regarding dependency and/or family law when I took over the division in December 30th of 2024.
So April 27th was the first that Mr. Knopfsinger brought up. He wants you off the case. I've never personally detected any reason to request a recusal here.
I mean, just, Mr. Knopfsinger, it doesn't hurt my feelings, but I have to follow the law. If no one files a motion, I can't rule on it. And also, you can't just wait a year and a half to file something, and then if there's a 30-day deadline. But go ahead and file your motion. I'll read whatever it says and make a proper ruling under the rule.
Your Honor, the reason it took so long is because I just found that statute. We have very limited means of seeing Florida state statutes in the county jail. So when our court-appointed lawyers only come to see us a week before court,
All right.
take a while.
Anything else you want to file as far as a Nelson inquiry, you're free to do so, Mr. Knopfsinger, but you can't wait till the case is set for trial and try to bring up things that should have been brought up a year and a half ago. All right, I'll see you on Monday, May 4th, 9 o'clock. Plea your trial.
You had a waiver for Teresa Phillips.
Ms. Phillips, so Teresa Phillips has a motion to suppress that's set for May 28th. So if we-
May 28th?
May 28th. If we could continue this to 6/24, knowing she'll be before the court on the 28th.
Clerk told me she's still got a minute sheet for
For who?
Andrew McDonald. Said he was continuing.
Yeah, I looked at Mr. McDonald's continuance. The order that was signed by the judge had all of his case numbers on it.
Maybe it wasn't filed in all three.
It did not, it wasn't filed in all three, but I looked yesterday because I was like kind of frustrated that he was still on, but the 1192 case is definitely on the order to continue.
But it wasn't filed in the case.
And then I have Christy Rainey.
Yeah, I think the 1192, it's not on there. So that's June 24th on Andrew McDonald.
Yes, Your Honor. Your Honor, this is Christy Rainey. If we could leave her on for plea or continue, we are trying to get Ms. Rainey into drug court. Mr. Sprouse is reviewing that. So if we could leave her on for Monday, plea or continue.
Without objection.
All right, plea or continue for Monday, May 4th, 9 o'clock. Ms. Rainey, we'll see you back on that day.
Your Honor, this is Kenneth Singletary. 25 CF 230. We have reached an agreement for Mr. Singletary. At this time, Mr. Singletary will withdraw his previously entered not guilty plea, enter a no contest plea as charged. The agreed-upon disposition is that Mr. Singletary will be sentenced to 36.25 months in the Department of Corrections with credit for all time served. He would be assessed $615 in court costs, $150 in public defender fees. He would be adjudicated. The state will no pros 26 CF 598. I believe that is on tomorrow's arraignment docket, but as part of this agreement, that case will be no pros. May I approach?
Yes, sir. That's going to be my next question.
And I wrote on the plea agreement no pros, but it should be no pros.
Information not filed, is that what you're saying?
It was not filed because this was anticipated.
Okay. And that would be a guideline sentence, 36.525, right?
Yes, Judge.
Oh, hold on. Plea agreement says 36.25. Guidelines say 36.525.
I would agree to a downward departure for the few days.
For 0.3 of a month. No, that's. All right, Mr. Singletary, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Kenneth Singletary, 10-280.
All right, Mr. Singletary, you're here in 25 CF 230, charged with possession of a weapon by a convicted felon as a second-degree felony and punishable by up to 15 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead as charged in that case. In return, you'd be sentenced to 36.25 months in the Department of Corrections with credit for all time served, $615 court costs, $150 PD fees. Those would be sent to judgment. Also, in return for that plea, the state has agreed to dismiss case number 26 CF.
Yes, sir.
598. All right. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
The other case, right?
That's what I just said.
Yes, sir.
Yes, the state is dismissing the 26 case for a plea to the previous case.
Okay. All right, Mr. Singletary, did you have enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Why, what's so funny?
No, I was just thinking about something.
What's so funny?
No, you asked me was I was under any influence of drugs or something. I'm not under the influence of no drugs.
I understand, but I don't understand why it's funny.
No, I was thinking about something.
Okay.
But no, sir, I ain't under the influence of them.
Okay. See, that's easy. Are you currently suffering from any mental health issues, Mr. Singletary?
I have in the past.
Okay.
But I'm
Have you
all
been
right.
previously diagnosed by a psychologist or a psychiatrist of a mental
No,
health
sir.
disorder?
No, sir.
Are you on any medications for such?
No, sir.
Have you ever been prescribed medications for anything like that?
Yes.
Okay. And when was that?
I was a teenager.
Okay. Do you feel that you need to be on that medication?
No, sir.
Do you feel as if you understand what's going on here today?
Very much. I understand.
Okay. Mr. Kleins, any concerns with your conversations with Mr. Singletary as to whether or not he understands what's going on here?
I've never had one concern.
Okay. Again, they're not tough questions, Mr. Singletary.
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've read to you?
No, sir.
All right, and do you understand by entering a plea, there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 1 and going on to page 2 of the agreement that you stated you understood and signed?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the possession of, is it a weapon or firearm?
It's a weapon.
Weapon. What is your plea to the possession of a weapon by a convicted felon?
No consent.
No contest?
Yes. Yes, sir.
I'll accept your no contest plea as freely, voluntarily, knowingly given in 25 CF 230. State have an announcement in 26 CF 598. All right, that'll be a no pros or no info by the state in Mr. Singletary's other case. I'm going to adjudicate you, Mr. Singletary. That's a felony conviction for you. Sentence you to 36.25 months in the Department of Corrections. Credit for all time served, $615 court costs, $150 PD fees. Those will go to judgment. This is a downward departure based on an uncoerced plea bargain to reduce it by 0.3 months. I need your fingerprints, Mr. Singletary, then you have 30 days to appeal the judgment and sentence of the court. Good luck to you, sir.
Mr. Singletary wants to address the court about something.
Anything else, Mr. Singletary?
Yes, with all due respect, I want to ask you, since the charges that I was in jail for got exonerated, they got dismissed, and where I can get like 2 weeks to get my affairs in order.
No, sir.
With my wife.
No, sir.
Okay, no problem. That's it.
That's it?
Gallen. Go ahead.
Oh, Mr. Nopes is back. Is this Thompson?
Right.
Ms. Rivers, you're on that one too?
Yes. No, I didn't. Okay. Because Sprouse had just said we were doing it on Monday.
I can't be here Monday.
Okay.
I'm getting the score sheet ready for
Okay.
Your Honor.
You want me to just pass it till they get everything together?
Is it a guideline sentence or what is
It's a
it?
downward departure.
Okay. What does he score?
I can tell you right now.
I assume you've got the information, it just hasn't printed yet.
He scores 34.875 months DOC.
Okay, and what is the negotiation?
The negotiation is for Mr. Thompson to be adjudicated guilty. There's a few charges that are going to be lesser included. He's going to do 1129 OCJ, and then followed by drug court for 3 years to pay. And he's going to pay restitution.
Drug court?
That's what.
Has drug court accepted him?
Judge, I asked my client about that, and I think he is set up to go for observation, but he's not been accepted yet.
They said
I've just never heard of anyone getting drug court after a jail sentence.
Well, it's just 3 years of probation, a condition of which he would attend and complete the drug court program here. And the reason for that is, we initially thought we were going to go to Phoenix House. Phoenix House does not allow them to use Suboxone. But drug court here, because they've started the MAP program at the jail, the drug court here will allow the Suboxone. And that's what helps with the addiction. He truly wants to kick the habit.
Well, I understand. My issue is not what y'all are trying to do, is just will it work as far as drug court being okay with that they've accepted him or not.
But my cousin called him, and I think Miss Oliver's running it now, and she said, yes, sir, as long as, she said as long, yes, they're.
I appreciate you're telling me
sorry.
that your cousin told you that, Mr. Thompson.
No, I know, she talked to Miss Oliver.
Can I respond?
Sorry.
I just want to make sure, because I don't want to go off on a bunch of tangents, and I'm just trying to tell you what my concerns are. That someone, either Mr. Sprouse or Mr. Nopes, your attorney, has talked to someone from drug court and says, yes, we can do that. I just don't want you to get out of jail, be on probation, and someone say you can't do that, and then we got to figure out what we're going to do instead of that. I don't like to set people up to potentially fail, Mr. Thompson. I want you to succeed. I want you to get past this addiction.
Yes, sir.
But
Thank
I
you.
want to make sure that we're doing it in a way that actually works for all the people who were involved, that program will accept you in that way. Because sometimes, for whatever reason, whether it's something in your prior history or something happens during the interview or something like that, where they say, well, that doesn't work for drug court. And I can tell you this because I've dealt with drug court since I was a baby defense lawyer, 20 years ago, that there are some things that pop up, such as, is there a crime of violence, a crime involving firearms, hold on, history regarding sales, manufacture, deliver, trafficking, they may not accept you because of that. So I just don't want it to be a situation where you do jail, get out, and now we can't do that program. What do we do?
Yes, sir. I'm really sure I don't have any of those disqualifying charges.
Do you know what all the qualifying things are?
I'm not a violent offender. I mean, no, sir,
Well, and that's my point. Neither do I. So I don't want to say that it's going to work unless someone has actually talked to the program to say, yeah, that'll work.
I think I've got 5 cases with Judge Reed in Fort Walton on Monday morning. My problem is I don't know exactly if I can get here by 11 or 11:30. I hope I can.
We normally go, well, it depends on what else is set for Monday.
The state will make itself available to ensure that everything is squared away and that we don't, have an agreement that we can't enforce.
Well, let me ask this. Ms. Rivers, you'll be here. Mr. Thompson, would there any issue with Ms. Rivers handling the plea without Mr. Nopes present?
I don't mind that, or I don't mind coming back in a month or 2 months.
Well, I want to get you down the road. I think there's some benefits to, especially if you're going to do a jail sentence.
Yes, sir.
That having your case done, because once you're post-plea, I think that opens up some opportunities for you in the jail that you don't have until you've made that plea. Again, I'm looking out for you, Mr. Thompson.
Thank you, Judge. You've been awesome. Thank you.
Well, I try to do what's right.
Yeah, I have nothing but happy with all y'all.
Yes, Mr. Nopes, come on up. All right, Mr. Thompson, what we're going to do is just have you back on Monday, make sure all the i's are dotted and t's are crossed, so we can get this done for you.
Yes, sir.
Mr. Nopes has some other court that day, so we're just going to work between my schedule and Judge Reed's schedule to make sure we can work it all out for you.
Thank you, Your Honor.
All right, we'll see you Monday, May 4th, for the
All right,
plea.
God bless.
All right, have a good day.
Your Honor, Vaughn Hill Treywick is out of custody.
Treywick?
She's before the court on 26 CF 406. We've reached agreement in this matter. If I may approach.
Thank you. I failed to give you 2 pages of Mr. Singletary's guidelines. All right, Ms. Treywick, when you raise your right hand, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, hand out of your pocket, please. Security's not going to like that. All right, Ms. Treywick, can you state your full name and date of birth, please?
Von Seal Treywick, June 18, 1974.
Okay, Ms. Treywick, you're here in 26 CF 406, where you're currently charged with possession of a controlled substance, which is a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would have you plead to a lesser included charge of possession of drug equipment, which is Florida Statute 893.147. In return, it'd be $270 in court costs, $50 PD fee, and a $50 application fee. I can give you 60 days to pay that, or, hold on, or set up a payment plan with the clerk's office. Can you do that?
Yes, sir.
Okay.
Yes, sir.
That's a little on the loud side, Mr. Mannix. Is that your radio?
It's, the COs have it really loud.
Okay, no problem. I just thought it was yours. I've never heard your radio before.
Only in my.
Okay. All right, Ms. Treywick, sorry for the interruption. Have you had enough time to go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with Ms. Rivers'
Yes, sir.
representation and advice?
Yes, sir.
All right, and are you currently under the influence of any alcohol, drugs,
No,
or
sir,
controlled
no.
substances? If you could just let me finish. We can't talk at the same time, otherwise it doesn't record very well. All right, Ms. Treywick, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right, are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
Okay. I've never heard anyone say yes to that, but I've got to ask it every single time. All right, and do you understand that if you enter this plea, there won't be a trial of any kind?
Yes, sir.
And do you understand you're giving up your trial rights, which start on the bottom of page 1 and go on to page 2 of the agreement you said you understood and signed?
Yes, sir.
And do you understand you're waiving all potential defenses you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and Ms. Treywick, what is your plea to the lesser included offense of possession of drug equipment?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, $270 court costs, $50 PD fee, $50 application fee. I'll give you 60 days to pay those or set up a payment plan with the clerk. I don't need your fingerprints because it's a misdemeanor, not enhanceable. So I tell you that you have 30 days to appeal the judgment and sentence of the court, but make sure you take care of those court costs. Thank you, Ms. Treywick.
I had a few others that were supposed to be out of custody.
I've got the list. You want Kevin Smith? Do we have Kevin Smith here?
He's not out of custody. He's in DJJ custody in Central Florida.
Okay. That would be why it was released in February to go to DJ.
Okay.
Okay.
Travis Stevenson?
Mr. McClellan is here and he's out of jail. Apparently they dropped that Alabama warrant yesterday. For the court's convenience.
What was his name again? McClellan?
Clovis McClellan.
Okay.
He was the fellow that was originally scheduled for Monday, and then he got picked up on that relatively stale Alabama situation.
The one that he gets picked up on all the time, you were telling us?
Yes, sir. And then I went out to see him yesterday, and he'd already been released, so.
Okay, Mr. McClellan, come on up. Oh, there you are. I thought, are you Mr. Stevenson? We'll call you next. I'm sorry, sir. All right, what are we doing with Mr. McClellan's case?
Judge, this is Clovis McClellan, 2026 CF 81. Judge, I'm going to move to continue the case. I've spoken with the state about it. They have no objection. This is inclined to ultimately getting his driver's license back, which will change the plea offer.
Okay. Mr. McClellan, do you know what you need to do to get your license back? You don't have to tell me that, but do you know what it is? Okay.
He's already been working on it, Judge, and has had some success with some of the issues.
Yeah, they're not always easy to track down, Mr. McClellan. That's why I want to make sure you stay on top of it.
Yes,
June
sir, I will.
24th, 9 o'clock, sir.
Yes, sir.
We'll see you back then.
Yes, sir.
All right, Mr.
sir, thank you very much.
Mr. Stevenson, can you come back up?
Judge, you said June 24th at 9? Did you
Oh, I'm
have
sorry,
that
June
earlier?
22nd at 1 o'clock. Sorry about that. You're right. I just got in the habit of saying it
Yeah.
because June 22nd, 1 o'clock.
Thank you, Judge. I'll get
All
my
right.
card.
And this is Mr. Stevenson.
Yes, Your Honor, that's Travis Stevenson, that's 24 CF 2689. Your Honor, he was just released from prison 12 days ago.
All right, what are we doing with this case?
So, Your Honor, at this point, I do need a chance to speak with him because he has been in prison. I believe we're probably going to have to set depositions. We're going to request a continuance to the 6/22 date.
That's without objection, Judge.
Mr. Stevenson, we're going to have you come back on June 22nd at 1 p.m. That'll be the afternoon. All right, thank you, sir. All right, did we address Thibodeau?
Yes, Your Honor.
Thought so.
Mr. Gilbert previously did a notice of appearance on that.
Oh, I'm sorry, we
pretrial
addressed
lapse.
that when you were in the room, but I wanted to make sure to bring it up because you were technically still listed as the attorney of record, but it was continued and Mr. Gilbert's handling that.
Yes, Your Honor.
All right, perfect. All right, and then the other person I have is out of custody is Elijah Murray. Did we address that on Monday?
Yesterday?
We did?
Monday? And
Okay.
he came to court.
List is outdated, Steve. All right, well, who do we want to call next?
Well, I have layman's lined up, matter of fact, the only that I have available for layman.
Mr. Maddox, where is Mr. Maddox?
Outside talking with a client.
Judge, I can step outside and let him know.
Okay.
Communicated with the jail about who's here.
Okay. Just for everyone who's here to see a family or friend, we're going to take a lunch break at some point, probably around the noon time, and then we'll come back at 1 o'clock. So I don't have a whole lot of control over who gets here when, as they're transported over. I try to get the people, Deputy Williams works really hard to get the people who have family members who are here to get their case called in the morning so you don't have to wait too long or come back in the afternoon. But again, we've got, we have 207 cases on today's docket, so it's not easy to shuffle all those things.
Somebody with family right now is Jacob Brown.
Jacob Brown, Mr. Maddox?
Yes, Your Honor.
Is that you?
It is.
Here's Ralph.
Your Honor, this is Mr. Jacob Brown before the court in 25 CF 1828. Could we put him on 5-4 for plea or continuance, Your Honor?
State, good with that? May 4th, Monday, plea or continue. We'll see you on Monday, Mr. Brown.
And Mr. Fields?
Just Sean Fields,
It is, Your Honor.
25 CF 1946.
Yes, Your Honor. Your Honor, I'd ask for a continuance in this case. I'm going to set a deposition of Mike Evans.
Anything else that needs to be done in the case, Mr. Maddox, that you know
That
of?
is the state's only listed witness at this time, so
Objection, Your Honor.
once the deposition is done, unless other witnesses are listed, no, I don't think anything else would need to be done, Your Honor.
Okay. All right. So June 24th,
Yes, Your Honor.
9 o'clock.
Thank you.
All right, we'll see you back on that day, Mr. Fields.
Patrick Curtis.
All right. Patrick Curtis, 26 CF 22.
Yes, Your Honor. Your Honor, we did get a competency report back on Mr. Curtis. I do have a copy of that. Does the state have a copy offhand? I think I sent it a while back, but I don't recall if I did or not. I believe it was internal. I don't know that Ms. Leone I want to stipulate to the report, so I do want to discuss it with her.
So that's Mr. Curtis, is that correct, sir?
Correct.
No, we will need to review it, so.
Give you a copy. Your Honor, do you want to put this on a miscellaneous date for a potential competency hearing? And then I need to provide the copy up to the court.
Your Honor, what I'll do is I'll have Ms. Leone review the competency report and make a determination if the state will be asking for a second report.
Okay. What date would you like to set it on? Do we want to set it on Monday, just kind of status to see?
Let's do that, Your
That's
Honor.
fine.
That way we'll be able to advise the court if we're seeking a second or if we can just go straight to the competency hearing.
Okay.
Yes,
Mr.
Your Honor.
Curtis, I'm just trying to keep you on as quick of a court date as I can to turn it around. We'll put you on May 4th, that's this coming Monday at 9 o'clock for the status on competency report.
All right, thank you, Your Honor.
And I've got my copy so I can review it before then. All right, thank you, Mr. Curtis.
Mr. Cutter Ford.
Your Honor, this is Mr. Ford before the court in 22 CF 1928. The last time we were here, he had just come back from the state hospital. The court did find him competent to proceed. Your Honor, it is an older case. I don't believe any depositions have been done in the case. I'm still going to need to work with the state to see if we can get something worked out on this case, Your Honor, before I move forward with, scheduling depositions or anything like that. So I am asking for a continuance on this case, Your Honor.
No objection.
Has there been a plea offer?
Yes, Your Honor, it was 10 years.
Ma'am? June 24th, 9 o'clock.
Thank you, Your Honor.
We got to have something figured out by then.
Work on it.
Uh,
I'll work. Takes.
All right, hold on. Every one of you, don't go out that door. If we have another outburst like this, ma'am? We're going to talk about contempt of court. You don't scream out from the gallery. You don't point fingers at people. This is a courtroom. Y'all need to act like it. Thank you.
I apologize, Your Honor.
Ma'am, come on up. Come on up. Your name? Is there a reason why you're screaming obscenities in my courtroom? Stand at the podium, please. I understand you're upset.
Because he's not doing his job. Nobody has been doing their job. My youngest been gone for 37.9 months.
Okay,
And he's not been sentenced.
was Mr. Maddox representing him
No,
then?
Gibbs wasn't.
Can I finish
Yes,
a
sir.
sentence, ma'am? You need to calm yourself, take a breath. I understand you're upset. However, I don't need people still commenting from the gallery, please.
Sorry, I am.
The court doesn't take anything that you're screaming out into account.
But I'm
Ma'am, hold on. That's why I'm trying to get you to calm down, relax, take a breath. I want to make sure you understand how this works.
I know. I've been in here before.
The process has to go through its normal path, okay? Screaming from the gallery, screaming obscenities is not helping your son.
It's not.
So I'd appreciate it. I don't have an issue with y'all having your shirts on. I don't have an issue with y'all standing up when he comes out. I didn't say anything about that. But when we continue his case and y'all start yelling and pointing fingers and screaming obscenities, it's not appreciated. This has to be a place of decorum. I'm not taking questions, ma'am. Ma'am, if you could put your hand down. The reason that she's up here is to make sure everyone understands what's going on here, and that further outbursts will be potentially dealt with as contempt of court, which, if it happens, you don't need to roll your eyes at me either.
Emily, stop. You're pregnant. Stop, child. I do this. I don't need you to.
This is a court of law. This is not a place where people scream out at each other. I'm just reminding you.
No, we know.
And I just want to make sure you
It's proof of
understand,
sale.
if you do something to upset the decorum of my court again, we'll talk about direct criminal contempt, which is punishable by 6 months in county jail. I don't want to do that. I've done it twice in my entire career for people who screamed obscenities at me, and I had no other choice. I don't like doing it.
Speaking to that man right there was when I was talking to. I wasn't speaking to you.
I understand, which is why you're not going back in the back room right now.
Yes, sir.
I understand you're not mad at me.
No, sir.
I hope not, because I don't think
Listen,
I've
you
made
don't
any
know me.
decisions in the case to be mad about.
That's right, you don't.
However, please respect my courtroom
Yes, sir,
and
I
the
will.
people who work in it, and we'll get y'all through this process. Just please don't scream out again. It
Yes, sir.
doesn't fix anything.
Yes, sir.
Thank
Yes, sir,
you.
go.
Have a good day. Thank you. I appreciate that. That makes a big difference. That is the one thing you can say in court from the gallery that the court will accept. Thank you.
Ms. Rivers is.
Not in the room.
In the meantime, I do have Tommy Allen from Mr. Maddox.
Who is that, Alan?
Tommy Allen, Your Honor. All right, Your Honor, we're going to have a resolution in this case. I just want to make sure that he understands everything, so I'm going to go over this with him in detail, pass him for this afternoon for resolution.
All right, Mr. Allen, we'll see you back this afternoon to finalize what apparently is your plea.
Yes, sir.
All right, have a good day. Or, well, have a good rest of your morning. We'll see you this afternoon.
Calmer that time.
Was he not calm the last time?
I have Mr. Dexter Bearfield. It's not a blue mark on the form, please, Judge, please.
Bearfield? This is Dexter Bearfield, 26 CF 114. First time up.
Your Honor, this is Mr. Bearfield. I would ask for a continuance, Your Honor. I am going to set depositions in this case.
All right, Mr. Bearfield, we'll see you back on June 24th at 9 o'clock.
You can go back yourself, but we're gonna bring you back out in a little bit. So just don't go back to the jail. We're waiting on his attorney, so he's gonna keep moving. But it'll be Bell and Brand. While we have a lull and they're getting people, Kenneth Kane is being a bigger problem for jail. What was anticipated to happen?
At the jail or here?
At the jail.
Okay, gotcha.
If they
Mr. Maddox?
bring him, they will accomplish that.
Yes, Your Honor. I do have a competency report back from Dr. McDonald. So I would like to get that resolved today. I believe it recommended sending him to the state hospital. be appropriate. Yes.
Mr. Maddox, do you think we could bring Mr. Kane by Zoom? Would that be an issue?
No, Your Honor. That's what we've done in the past. That'd be fine.
If that makes it easier for the jail and what's going on, we can do it by Zoom this afternoon.
I believe this one was a court-ordered report, but if it's not, I do have a copy for the court, Your Honor.
I've got it.
Okay.
It's filed.
Excellent.
I think I saw it already.
And I believe the state's willing to stipulate to it.
Okay.
That is correct, Your Honor.
Well, we'll have to get him on Zoom so
Yes,
he's
of
present
course.
for it. And he can go. All right. If they want to do it on Zoom, if they could get it around 1 to 1:15, just because I'm going to have the interpreter case, we'll probably finish that about 1:15, then we can take them, if that works. All right, who do we have?
This is Mr. Bell, Your Honor.
Bell?
25 CF 1498, depositions are set June 17th.
And?
I would ask for a continuance, Your Honor, to do those depositions.
All right, June 24th, 9 o'clock, depositions are set for the 17th. Thank you, Mr. Bell.
They will be keen on Zoom between 1 and 1:15.
Okay.
And then Brand. Mr. Brand.
State still intend to announce for trial, or push for trial in this case?
Yes, sir, she does have down plea or trial.
Plea trial,
I
okay.
have the offer already.
Plea
So you're-
trial?
Yeah, plea or trial, Your Honor. If we could put him on docket day for 5/4, I'll come see you again. Oh, stay right here. He's gonna announce it to
Hold
you.
on. You write it down first, and then I'll announce it. All right, so this is Christopher Brand, 25 CF 848. It's going
Yes,
to be
Your
set for Monday, 5/4, plea or trial.
Yes, Your Honor.
All right.
Buckles.
All right, Ryan Buckles, 25 CF 2491.
Yes, Your Honor. It's the first time up. I am asking for a continuance in this case.
Is it the first time up?
I believe so.
It's from December.
429. Yeah, I had 429 done. If it's not, though, I am asking for a continuance, Your Honor. I do need to continue to investigate it. I am looking into the blood draw. There may be issues there. Also, this is a weird DUI in the sense that there's no in-car camera or audio available in the case. So I've sent the state emails about that, but the response I've gotten is that there's nothing available, so I'm also looking into that, Your Honor. Probably will need depositions in this case, so a bunch of moving parts here, but I intend to make progress on it here with this cycle.
All right, let me just kind of set the record here. Mr. Buckles was arrested 12/18 of 25. He had an arraignment on January 19th, where it was set directly to today's date.
Okay.
So this is his first pre-trial. However, just to put it out there, he did a demand for a speedy trial himself. While represented, I did an order striking that demand since it was done not through counsel.
Correct. And I had spoken to him about that, and I believe we addressed it previously, but if we hadn't, I've spoken to him about that. That's not an issue at this point, Your Honor.
You agree with that, Mr. Buckles?
I really would like to see what you guys are offering and where we're going with this. I mean, I wasn't even driving.
Well, don't talk about the facts of your case.
I'm sitting in jail for.
The state's offer was 5 years DOC.
Correct. Yours, do you see? He's 433. Yes, sir, you do.
Not going for that.
Oh, I know.
Anything else from Mr. Buckles?
No, Your Honor.
June 24th, 9 o'clock.
Thank you.
Thank you.
Good morning.
We have a competency report indicating that you're. Mr. Sprouse, are you willing to stipulate to the report, or are you going to seek a second one?
I'm willing to stipulate.
May I proceed, Your Honor?
Yes. Understanding Mr. Camarda has another pending case.
Yes, Your Honor.
That's 26 CF 538.
Don't think I have it in front of me, but that sounds right, Your Honor.
Set for arraignment tomorrow.
Yes, Your Honor.
You do represent him on that, right, Mr. Maddox?
I believe so.
All right, so I've reviewed Mr. Camarda's competency evaluation, understand the genesis of it.
Yes, Your Honor.
Dr. Zeman's report also talks about his medical review of his records.
Correct.
You are stipulating to this?
We are.
Yes, Judge.
Stipulating to the court making its decision based on this particular report?
Yes, Your Honor.
Okay. I guess my one question is, I think it's clear I can find him incompetent based on this, but what happens next?
It doesn't appear.
It doesn't really recommend. It says basically doesn't meet criteria for certain things, but.
Dr. Zeman opines that it does not appear, due to the nature of his findings, that he is eligible for any form of competency restoration, Your Honor. So I would maintain that he's unrestorable at this point.
Well, but I don't think that's what the report says. What the report says is this situation, which occurred back in September of 2025, can take as much as 2.5 years to kind of get to a kind of maximum level of improvement.
And if that's the court's finding, that's perfectly fine, Your Honor. We can certainly give it a shot. But on the next page, it says, additionally, it's my understanding that given the nature of his current incompetence, being secondary to traumatic brain injury, he's not eligible for any form of competency restoration, nor does he meet criteria for involuntary hospitalization. So we could try a conditional release plan or something to that effect, I suppose.
It's a great idea, Mr. Maddox.
All right, Your Honor.
My
I'll
concern, however,
yes, sir.
is that he's picked up another charge while out on release. And I understand the nature of the charge. It's possession of ammunition by a convicted felon. which ammunition by itself isn't necessarily dangerous, but my concern is what's the next step?
I understand the court's concerns, Your Honor.
I suggest what we do is a conditional release plan. If you can get me an order with these terms, that he's to not possess, it's already illegal to do so, but possess any, he can possess any firearms or ammunition or any other dangerous weapon.
Yes, sir.
Is he residing with his mother? Is she present?
I don't think she is
No.
today, Your Honor. If the court does need to hear from her, I'm sure I can arrange for her to be here on Monday.
I don't think I need to, I just want to make sure.
Of course.
Because is discussed in the report as well.
Yes, sir, Your Honor.
One concern that the state has, Judge, is there, as far as David and NCIC are concerned, they have conflicting information. Mr. Commander should not be driving. He's not allowed to drive. He's been convicted previously of possession of controlled substance within the last year. So I would ask that he not be allowed to drive per court order. And it's also the reason why he has an injury is that he's not able to drive.
All right, what I'll say is, Mr. Camardo, you're not to drive a vehicle unless you go through a evaluation through the Department of Highway Safety and Motor Vehicles to determine whether or not you're medically cleared to do so. Even then, I'd like to see it before that happens.
Yes, Your Honor.
I'd like to also give him a 6-month follow-up date for court to see how things are progressing. I mean, even at that point, we're only 1 year post-accident, but I think we need to keep our finger on the pulse here, Mr. Camarda. But if you have to understand that if you were to commit some other new offense, we're going to have to be concerned about whether or not you're a danger to yourself or others. And that could change whether or not a conditional release program will work for you.
Absolutely, Your Honor.
Okay. Also, that's part of the order that he's to attend all necessary medical and appointments that he has.
Does that include anything he schedules himself?
Yes.
Okay.
What about tomorrow's case?
Has the state has filed on that?
I'm sorry,
Tomorrow's
on
case?
the new case?
Yes, it was filed.
Okay, then we'd enter a plea of not guilty, Your Honor.
Okay.
And demand trial by jury.
Does he have? He currently has a $5,000 cash or professional bond on that case. Does the state have any objection to releasing him ROR with the conditions of this case?
The state has no objection to an ROR bond for Mr. Kamada.
Okay. So as far as 26 CF 538, he'll be given an ROR, but he has to follow the conditions of this case as well.
All right, Your Honor. So I have attend all necessary medical appointments, a 6-month follow-up date, no possession of any firearms or any other dangerous weapon or any ammunition, and no driving without an evaluation and medically cleared to do so.
Yes.
All right, thank you, Your Honor.
Let's put him on Thursday, October 29th at 9 o'clock for that follow-up date.
October 29th, Your Honor?
Yes.
All right.
All right, thank you, Mr. Camarda.
Thank you, Your Honor.
I've ordered it. I want to make sure that you get an order to me to make sure he gets released.
Yes, Your Honor.
So do that as quickly as possible. I just don't want there to be any confusion.
I won't leave without doing it today.
All right. Do we know of anyone else who has family members in the?
We do, and the vehicle sounds like they're just pulling in now.
Okay.
That would include some of those
I'd like to see if we can get those resolved and then take our lunch break.
As soon as I have them and the attorney representing them, I've got Mr. Peterson here. I think Lisa went to eat something. Yes.
Yeah.
As soon as I have them.
All right.
State stipulated report.
Yes, please.
Your Honor, this is Mr. Carpenter before the court in 25 CF 1405. Your Honor, I do have back the results of his competency evaluation. I believe I did it internally, if I may approach.
Yes.
I believe it recommends the Fuller State Hospital, Your Honor. The state and I would agree to stipulate to the court making its findings based on this report.
And the state's reviewed the report and stipulates for your honor, relying on it for your decision.
Hold on just a second, sir. I'm reading the report. I reviewed Mr. Carpenter's report by Dr. McDonald finding or opining that he's not competent and is what should be restored in the Florida State Hospital. Parties have stipulated to the court making its decision on this report.
Yes, Your Honor.
Okay. Mr. Carpenter, was there something that you wanted to say?
Yes, sir.
Go ahead.
I'm having heart problems and stuff, and I'm not getting no help in anything at the county jail.
Okay, well, based on my reading of the report, I'm going to find that you're not competent to proceed and then have you put into the custody of Department of Children and Families and the Florida State Hospital so they can take care of you. Okay. Anything else, Mr. Carpenter?
No, sir. About how long will that take?
I wish I could tell you that, Mr. Carpenter, but I'm sure your attorney will follow up to make sure it goes as quickly as possible. My understanding is that males are being moved relatively quickly, but the females not as much.
Correct, or at least that's what I was told last time I inquired.
The last time I heard it, and it may have been from you, Mr. Maddox, but do y'all want this filed under confidential?
Yes, Your Honor.
I tried to Baker Act myself 2 days before I got arrested in Crestview K-9
No,
officers.
you don't need to talk about that, but yeah, I'm aware.
Okay.
It's talked about in the report about previous BA. All right, thank you, Mr. Carpenter. They'll come get you and help you out.
All right, man.
Thanks,
All
sir.
right, we'll see you soon. You too.
Your Honor, this is Mr. Collins before the court in 26 CF 69. Your Honor, it is a first time up. I would ask to set this for May 4th for plea or continuance.
All right, Mr. Collins, we'll see you back on Monday. Plea or continuance, that's at 9 o'clock.
Mr. Comey was addressed by Brad Stewart, covering for somebody else, and he said that he wanted to.
You have Mr. Comey, apparently Mr. Powell.
It was
Two of the Powells.
Mr. Comey. So I went back and checked to make sure that I wasn't still appointed in that case. I am showing as.
Or, I'm sorry, you're right, it's Welton. Thank you, Matt.
I am showing as the appointed lawyer, Your Honor. However, I went back and looked, and it does appear that the motion to withdraw and the order to withdraw has been placed in that case, and
I think it was in one case, but not the other was the issue.
Okay, but my understanding is he's taking over all of those cases.
It was addressed with Brad Stewart covering for Mr. Welton, but I just wanted to make sure you knew of that, so it wasn't a situation where you were asking where your client was because you hadn't been told.
Yes, Your Honor.
All right, so he's good.
Thank you.
Mr. Cooper.
Had a lot of competency evaluations. I apologize for that. Your Honor.
Yes.
Does the court have the benefit of this one? I think this one was internal too.
Who's that?
Mr. Cooper, Your Honor, Malik Cooper, 25 CF 2245.
Yes, I reviewed it. I put a note in my,
Excellent. State good stipulated to the report.
State stipulates, Your Honor.
I think you must have emailed it to me, because I
I
know
may
I read it
have.
because I made a note of it.
May have tried to move him up at some point, but we'll get it handled today.
He's had a whole bunch of people get off the elevator, so.
Malik Cooper, yes.
Oh, did you have Harry Dash on today?
The females are
Oh, okay,
probably
okay.
on this load, so.
I got you.
58 Harriet Avenue.
Well, if there's no one specific we need to resolve for purposes of getting people out of here.
Right, I'm waiting on Samantha Forrest, who has family here. Ryan Peterson is here. We're waiting on Lisa Rivers. And then I have Bryson Shanklin, William Matthews with Mr. Williams, and Jonathan Nichols with Mr. Williams. I don't know who.
Is Mr. Williams here?
But if you got the females, 58 and.
You have one I can resolve, Miss Monday, Your Honor.
All right, Sarah Munda,
Yes.
come on up, ma'am. She under you, Mr. Maddox?
She is, Your Honor. It's from a long time ago. 24, it's a 24 case. There were some competency situations and some other complications that arose, but we're ready to resolve it today. Date. Today's the 29th. 4/29/26. May I approach, Your Honor?
Yes.
Let's begin the microphone. Yes, sir. No, sir. Take it seriously.
All right. Ms. Munda, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Tara Ashley Munda, September 7th, 1988.
Okay, and Ms. Munda, you're here in 24 CF 2820, where you're charged with felony battery, a third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
I've been handed a plea and sentencing agreement that would have you plead no contest to that charge. In return, it'd be an adjudication of guilt. That's a felony conviction. Do you understand that?
Yes.
You're to do 11 months, 29 days of probation. It's not to a misdemeanor, right?
No, it is not, Your Honor.
Why is
It's
it
actually-
11/29 instead of just a year?
That's fine. We can do a year.
I just
That's just how it's used to doing it. But
just wanted to make sure I wasn't missing something where it said it was supposed to be a misdemeanor.
No.
All right, so 1 year probation, you're to do a mental health evaluation, any recommended treatment, $967 in court costs, $150 cost of defense, no trespassing at the McDonald's at 302 James Lee Boulevard here in Crestview, and no contact with Cody Altman. Is that the agreement that you've made, Ms. Munda?
Yes, Your Honor.
Did you have enough time to go over this with your lawyer?
Yes.
Did you understand it?
Yes.
Did you sign it?
Yes.
Are you satisfied with your lawyer's advice and representation in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Okay. Are you currently suffering from any mental health issues?
No. Oh. Oh, no, I was just, I've had a mental health evaluation. Does Zimmerman, does that
You can talk
count?
about that if you want.
Yeah, does Zimmerman, does that count for anything?
Zeman, you mean?
Oh, yeah, I guess
Okay.
Zeman.
And then that's previously been discussed in court. But you'll have to have a further mental health evaluation as part of your probation. Do you understand that?
Yeah, yes.
Mr. Maddox, any concerns with her appearance and understanding today?
No, Your Honor. I've spoken to her about this plea agreement several times, including today. This is what she wants to do. Quite frankly, this is her normal appearance to me. She does speak rather quietly. So no, I do not have any concerns.
All right, Ms. Munda, has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything other than the terms of the agreement that I've announced?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes.
Do you understand you're giving up your trial rights, which are listed on page 2 of the agreement you said you understood and signed?
Yes.
Do you understand you're waiving any potential defenses that you may have?
Yes.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes.
And Ms. Munda, what is your plea to the one charge of felony battery?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty. 11 months, 29 days of, 1 year of probation with the Department of Corrections, a mental health evaluation, any recommended treatment, $967 in court costs, $150 cost of defense, no trespassing, which means do not go back to the McDonald's on 302 James Lee Boulevard in Crestview. Do not have any contact with Cody Altman. Ms. Munda, I will need your fingerprints, and you have 30 days to appeal the judgment and sentence of the court. After your fingerprints, make sure you speak with probation, who's sitting there behind you. This is a guideline sentence, as she scored 17.30 points.
All right, thank you, Your Honor.
All right, thank you. Step up and be fingerprinted, ma'am.
Up this way, please. Stand right here for me, please. And I have Ms. Ash for you, Mr. Maddox. Ms. Ash? Stand in that blue marker over there, please. Face the judge. Right there.
Your Honor, this is Ms. Ash before the court in 25 CF 2000. Your Honor, I am asking for a continuance. I'm going to set depositions in this case.
June 24th, 9 o'clock. Thank you, Ms. Ash.
And then I have Ms. Forrest. Please.
Your Honor, can we set this for May 4th for plea or continuance, Your Honor?
Is that what we did on the co-defendant too?
Last continuance on the co-defendant, Judge. But we have no objection. Well, I have 624 that I wrote down. Like, this is gonna be the last continuance because.
This will be the last continuance for the co-defendant, is what you're
That's
saying?
correct.
Okay.
So-
I just don't want to flip back and find it, so if everyone knows.
Correct. Because Mr. Klein's is gonna be in receipt of reciprocal discovery and sending it to the state, so that's why we have it set for this last continuance.
May I speak, Your Honor?
Hold on just one second, Ms.
Yes,
Forrest.
sir.
You're going to get your chance. I just want to look up what we had talked about. All right. Go ahead, Ms. Forrest.
With all due respect, Your Honor, I think that there's a conflict with my public defender.
Okay.
I don't trust him.
So you're saying,
I really, I think that I need another attorney.
okay.
I made a list of things that.
Have you filed anything with the
I
clerk's
have
office?
not, because I did not know the process. I spoke with outside counsel, who had given me some advice on what I needed to do today, because I wasn't originally planning to do this. But I just feel like that is where, that is not, I think that's, right now, what I feel is the right thing to do, because I don't feel that I'm being represented with my best interest.
All right, well, what you can do is you can file something that says, these are the reasons that I have a concern as to why my attorney has not been effective advocate and counsel to you. And then we can set that for a hearing. But I need to know what those things are in advance. Your attorney needs to know what those things are in advance. Just understand that if you're pursuing that, he's going to basically not work on your case because he doesn't want to do anything that could cause any issues where you'd come back and say, well, I didn't want him to do that. That's why I said he was ineffective.
Well, he hasn't, in the meantime, hasn't been anything that I've been asking him to do.
Okay.
In the meantime, and since August. So, lack of communication, unwillingness to do a whole lot of things.
I'm not going to address it
Address
today,
that.
but what types of things are you talking about?
There's a lack of communication, unwillingness to consult with outside counsel that had previous knowledge.
Outside counsel?
Yes, it's like a side counsel, yes, who was willing to, just for advice or.
Why does he have to talk to another
I don't
lawyer
know.
about the case?
He doesn't have to, but I asked him to. I just asked him.
If there's some other lawyer who wants to represent you, they can do that.
I understand that, sir.
That's what I told her, Your
I
Honor.
wish that I could afford another attorney to do that for me, but I do not have those assets.
Well, I'm telling you, Ms. Forrest, I was a criminal defense lawyer for 15
Yes,
years
sir.
before I took the bench. If someone told me I had to go talk to some other lawyer, I'd say,
That's
you're
not
free to
right.
hire that person.
Yes, sir. Yes, sir. And that was a discussion that we did have. But also that there's evidence that's not being brought.
Such
I believe
as?
forward, the fact that my victim has dementia, his medical records aren't being discussed right now. I don't believe that his deposition or any testimony that he would give in court would be to the recollection.
Can I see that list?
Yes,
If you're
you
just gonna
can.
read off. I may be able to just,
I mean, if we can, but we had a discussion on.
Hold on.
So he's telling you to not say anything else for your benefit while he looks at it really quick as to what your
Yes,
list
sir.
is.
I don't want to.
Ma'am, just let him look at the list really quickly.
sir.
I will say that Mr. Maddox has negotiated this case extensively. The offer was, that this, as is charged, is punishable by life in prison. We've had depositions. The state's ready to go to trial. I think the gravity of the situation is maybe lost on the defendant. Right now, the offer is 24 months DOC, which matches the co-defendant's offer. I'm not going to take it off the table today, but I'd be inclined to reconsider the offer. It would probably go up.
Okay.
Because.
Ms. Forrest, this is not for you to have a conversation with the state attorney at this point, but
Because the state, there's a lot of witnesses in this case, and I won't belabor the point, but the state makes bargains for people to accept responsibility, to give that opportunity. And if that's not going to be accepted, then we would just move forward to trial, because it's very serious.
All right.
Children are also there, sir.
I'm not going to take testimony from anyone. That's not how it works. Yeah. But you have to understand that if you're charged with something, this,
I understand the process, sir.
can I finish now, Ms. Forrest? If you go to trial on that charge, burglary with battery, it's a life sentence. Do you understand that?
I do
Well-
not want to go to trial.
Possible life sentence.
Forgive me, Your Honor, I thought it was charged as a burglary of an occupied dwelling as stands.
What did you charge it as?
So, I have burglary occupied dwelling, but if it goes to trial, I foresee I'll charge it as a burglary with a battery, because that's.
That is what
Is that what it originally was charged as?
No, there
Or the arrest was made for?
Armed burglary was what the arrest was, what initially portrayed. The state filed as burglary of an occupied dwelling, and then Mr. Sprouse has conveyed the intention to heighten the charge if she does decide to pursue trial, and potentially even if she just rejects the offer.
And Ms. Forrest, I'm just trying to make sure you're hearing all this so you can make your decisions based on what's been discussed.
Your Honor, I know that the court doesn't want to deal with this today. I've reviewed the list. She's welcome to file this if she desires, but I could offer a brief response if I may.
At this point, I'd rather, Ms. Forrest, if you, Ms. Forrest, okay, I just want to make sure you understand. Most people don't listen very well when they're talking. Also, it's hard to hear two different people talking at the same time.
I apologize.
Third, so you're still doing it. Third is everything in this room has to be recorded. It's legally required. So if people are talking at the same time, you and Mr. Maddox, you and the prosecutor, me and you, or any combination of those people, then the record doesn't come up very good as far as what's been recorded. So you just have to wait your turn.
Yes,
As far as any concerns you have with your lawyer, put it in writing, file it with the court. I'll have what's called a Nelson hearing to determine whether or not Mr. Maddox has either done something ineffectively or failed to do something that he should have done or done something he shouldn't have done. And then I'll make a determination as to whether or not I'm going to appoint you new counsel. But we don't do these things on the fly. If you want to file something and get it done, we can get you back on a docket as quickly as possible, but you need to kind of put it in writing so everyone can prepare for it. When you just pull out a list and start naming things, it makes it hard for anyone to respond, especially your lawyer who doesn't know this is coming, and he has to be able to, I don't want to say defend himself, but be able to respond as to that he hasn't done anything ineffective. And then I'll make a determination as to whether or not I'm going to appoint you a different lawyer or you're going to go forward with the public defender's office.
Yes, Your Honor. If she does file that, I'd be prepared as soon as the court is wanting to set it.
Okay. All right. In the meantime, I'm going to put you on June 24th, Ms. Forrest, at 9 o'clock. I'd like to have that issue resolved well in advance of that, so make sure you file anything. Once you file anything like that, it actually, once the clerk gets it and processes it, it gets emailed directly to me. So I see it as soon as it's processed, and then I'll set it for the next possible hearing. All right. Thank you, Ms. Forrest. Anyone else?
I have two with Jay Williams. Is there still family for William Matthews here?
Judge, I don't see them. I know she was here a little while ago, and I've spoken with the client, and we're ready to proceed. Who's
Well, I'm just trying to handle people who have family members here so we can resolve that, and then we can take our lunch break and come back at 1 o'clock.
Yes, sir. Is there family for Jonathan Nichols here? Okay. Mr. Nichols.
Morning, Judge. This is,
Yeah, we're afternoon.
This is Jonathan Nichols. Case numbers 25 CF 2337. Judge, what I'd like to do is leave it on for docket day, plea or continuance. I did some research, originally planning to file a motion to dismiss on it. I'm not going to be able to do a motion to dismiss because the case law I'm looking at says everything that it's a jury question. But there are some issues with the jury instructions. Ultimately, I may wind up having to do it as a motion in limine based on what the state's indicated that they're going to proceed forward on. I want instead just to sit down with the state, show them the case law, show them the change in the statute and the jury instruction and see if we can reach an agreement on it. And what I'm hoping is that after I show him all this, we'll get a little bit better offer.
Okay. So we're going to leave it for Monday?
Yes, sir. I'd like to do that, though, plea or continuance.
All right, Monday, May 4th, plea or continuance, 9 o'clock.
Thank you. All right, so that's what we'll do.
So I know the gentleman just likes to come and watch.
Yes.
Okay. I don't know who you're here for.
He's our biggest fan.
So that's our family.
Or maybe he doesn't like us at all, I don't know.
Have Matthews here because there was family, he's pleading.
Well, did they leave because they're gonna come back at 1 o'clock?
Judge, I don't know, I haven't had that conversation with, they were aware of what the plea offer was.
Okay.
And so they may be going ahead and looking forward to.
Well, I'd like to give everyone a lunch break, so we're already pushing 12:21, so let's just come back at 1 o'clock and we can take them at that point.